May it please the Lordship. Your Lordship, I am appearing for item number 12. Your Lordship, my senior is in Kohima. And Your Lordship, we are praying for fixing the matter in the next week. May Your Lordship please kindly fix the matter.
Respondents, you are appearing.
Yes.
It is submitted that the learned counsel leading the matter is attending matters in the Kohima bench. Full stop. A prayer has been made with the consent of the learned counsel for the respondents that the matter may be taken up on the next week. Full stop. Accordingly, list this matter again in the next week.
Deeply obliged, Your Lordship.
Ladies, item number 1.
May it please the Lordship. This petition is relating to my lord payment of subsidy. The government of India has announced a scheme that is Central Capital Investment Subsidy Scheme 2007. In short, it is called NEIIPP 2007. The policy, part of the policy, I have enclosed in Annexure 1 at page, my lord, 27. The commencement and duration, second column, that it will come into effect from 1st of April 2007 and remain in force up to and inclusive of 31st March 2017. Applicability, unless otherwise specified, all new industrial units as well as existing units which go in for substantial expansion and are located anywhere in northeastern region, in short NER, will be eligible for capital investment subsidy under this scheme. This scheme will also be applicable to the following service sectors, activities, industries as service sectors, that is hotels, adventure and leisure sports, including ropeways, medical and health services, international and home center, old age homes, vocational training institutes.
Which one do you fall in?
Clause 3, my lord, applicability.
Out of these service sectors, which are you?
Where my lord? This is an industry, my lord. It's, my lord, it is not service sector, it is an industry.
Industry.
They are manufacturing industries. They are manufacturing, my lord, in goods. Then I'm reading to my lord, clause 6. That is plant and machinery. All industrial units, new and old. So ours is an industrial unit manufacturing iron, my lord, iron ingots.
Scheme will be applicable to the following service sector activity and industry.
Yes.
Hotel.
All these are service
Medical and-
sector, from service sector.
Medical and health. Vocational training institute. Biotechnology industry. Power generating industry. What is Annexure 1?
The definition is there, my lord. Industrial unit means any industrial, clause 4. Industrial unit means any industrial undertaking suitable servicing unit other than that of run departmentally by government. New industrial unit means an industrial unit for the setting up of which effective steps were not taken prior to so and so. 2007. Existing industrial unit means an industrial unit for the setting up of which effective steps were taken prior to so and so. Substantial expansion means expansion. Here is, it is an expansion. Expansion means increase in the value of fixed capital investment plant and machinery of an industrial unit by not less than 25% for the purpose of expansion of capacity, modernization, and diversification. So my industry is, my lord, on expansion, substantial expansion. 4D, it is not falls under service sector. Then 1.5 I'm reading that all eligible industrial units located anywhere in the northeastern region shall be given capital investment subsidy at the rate of 30% of their investment in plant and machinery or additional investment in plant and machinery. Such subsidy will be applicable to units in the private sector, joint sector, cooperative sector, as well as the units set up by the state governments concerned of the northeastern region. The limit of automatic approval of subsidy at this rate would be rupees 1.5 crore for grant of capital invest subsidy higher than rupees 1.5 crore, but up to a maximum rupees 30 crore. There will be empowered committee set up by number so and so, so and so.
Hmm.
Proposals which are eligible for a subsidy higher than so and so will be placed. It is not applicable to my case since it is a lesser amount. Plant and machinery, clause 6, for manufacturing sector. Ours is a manufacturing sector. In calculating the value of plant and machinery, the cost of industrial plant and machinery as erected at site will be taken into account, which will include the cost of productive equipments such as tools, jigs, dies and molds, insurance premium, etc.
Hmm.
Second and third is not applicable. Then 6A, definition of plant and machinery. This is important in this case, my lord. Definition of plant and machinery and components which should be taken into account for the purpose of this scheme in respect of service sector, biotechnology industry and power generating industries referred to in para 3.1, 3.2 and 3.3 above could be notified separately. Designated agency of disbursement of subsidy, all these are common thing applicable to all the subsidy schemes. So I don't think so. I should place before your lord. In the present case, what happened, my lord, that after the scheme, my lord, the petitioner submitted the application, which was in my lord format. In standard format, they filed the application. Thereafter, my lord, the page 31, after verification and my lord inspection, the GM in District Industrial Center, Commerce Center, Tinsukia, he has forwarded a letter to the Director of Industries Assam that I have the honor to forward herein the 30% CCS claim application of Messrs. So and so, so and so, so and so, under the Northeast Industrial Investment Promotion Policy, so and so, with all relevant documents as submitted by the applicant unit. The case is duly inquired by Sri so and so, functional manager of this DICC. The admissible amount of investment in plant and machinery comes to rupees 4 crore 96 lakhs so and so, so and so, and 30% CSS recommended to the unit is rupees 1 crore 48 lakhs so and so only. So, my lord, in this case, present case, on the first application, my lord, there was rejected, but my lord then approached this court, and court has allowed the petition, read petition, and they got out of 1 crore 48 lakhs, they received 1 crore 14 lakhs, already received. But this is the second petition, why they have to come, why on imaginary, my lord, calculation, they have deducted 1 crore, no, they have deducted 34 lakhs, which is not permissible under the scheme, as it is recommended by the GM. It was wrongly interpreting the scheme and
So whatever was recommended by Annex
DICC.
3, page 32, you have received it.
not received fully. Then I
No.
have to file the second writ petition.
Kindly,
It was recommended 1 crore 48 lakhs. Out of
kindly
the-
come to page 32.
Yes, ma'am.
This was the meeting,
Meeting.
and at page 35,
Yes, my lord.
serial number 2A,
Yes, my lord.
approved was 1 crore 14 lakhs 41,000 something.
Exactly.
That you have received.
Yes.
That you have
That is
received.
grievances.
No, have
That
you
I
received
received,
it?
yes.
So that is received.
Yes.
So you have received this. You are saying that whatever was forwarded by
Lakhs less. Yes.
the letter at annexure 2, page 31, that
Yes.
you have not received,
Yes.
you have received less.
Yes.
Okay. Then what
34
happened?
lakhs. Why they have cut? That is, well, in the affidavit, first
No,
my
where is that order of this court?
order is
Earlier order?
not my lord. First order was at page 41.
Hmm.
General order, several cases were there. Uh, of that, their writ petition was, my lord, at TMT bus, page 44.
Ah,
Some writ petitions clubbed together, my lord.
yes.
Yes, the government of India in the Ministry of Commerce and Industry. I mean, so. The history is written here, my lord. Should I read it?
Hmm.
Yes. Ministry of Commerce and Industry Policy Promotion introduced a scheme called Central Capital Investment Subsidies in 2007 for industrial unit in the northeastern region comprising of states of Arunachal, in view to accelerating industrial development in the northeast region. As per the Central Capital Investment Subsidy Scheme 2007, all eligible industrial units located anywhere in the northeastern region shall be given Central Capital Investment Subsidy, 30% of their investment in plant and machinery or additional investment in plant and machinery. The limit of automatic approval of subsidy at this rate would be so and so, and for grant of CCS higher demand course, but up to maximum rupees 30 crores. There shall be an empowered committee. Proposals which are eligible for a subsidy higher than so and so will be placed by the Department of Industrial Policy and Promotion before the Union Cabinet for its consideration and approval. Northeastern Development Finance Corporation Limited, Guwahati shall be the designated nodal agency for disbursement of CCIS under the 2007 scheme on the basis of the recommendation of state level committee, so and so, and Union Cabinet as the case may be. The 2007 scheme was framed in pursuance to the Northeastern Industrial and Investment Policy 2007 and was notified on 27/7/2007. Petitioner applied for registration under the so-and-so scheme, submitting all necessary documents. General Manager, District Industries and Commerce Center, Tinsukia, informed the petitioner by letter dated 16 February 2008 that it was registered under the 2007 scheme. Petitioner was requested to submit its claim in the prescribed form, and accordingly petitioner submitted its claim. Thereafter, General Manager, District Industries and Commerce Center, Tinsukia, issued certificate for registration dated so and so to the petitioner. The said General Manager, by his letter dated so and so, 24th of December 2008, forwarded the 30% CCS claim to the petitioner to the Director of Industries and Commerce, a sum to be placed before the SLC, means State Level Committee. It was stated that claim of the petitioner was duly inquired into by the concerned manager. Admissible amount of investment in plant and machinery comes to rupees 4 crore 96 lakhs, and 30% of TCS recommended is equal to 1 crore 48 lakhs. A meeting of the SLC for grant of 30% and 15% CCS respectively was held on so and so. In respect of the petitioner, the SLC considered its claim eligible investment was assessed at rupees 1 and rupees 1, which was approved. Petitioner was accordingly informed by the Office of the Commissioner of Industries and Commerce, Assam, that its 30% CCS claim amounting to so and so was approved by the SLC. Petitioner was therefore requested to take the required follow-up steps. However, petitioner was informed by the Office of the Commissioner of Industries and Commerce, Assam, filed letter so and so, and the meeting held on demand was of the view that dual benefits under spine. That another question has come, my lord, here. A dual benefit under spine or the T-board should not be given to those industrial units availing CCIS. If an industrial unit intends to avail CCIS incentive, it has to surrender its claim under spine or the T-board. Following the same, the petitioner was issued a so-called notice dated so and so by the Commissioner of Industries and Commerce.
Yes, we have seen that it was first allowed, then there was a writ appeal. It
Yes,
was remanded back. It was remanded back. Then there was another direction. Where was it rejected?
Then the repetition, bunch of repetitions are allowed again, Manual, the reported case. Manual Justice Surana. Thereafter, again, they went for writ appeal, and that their writ appeal was dismissed.
Then,
Then, Manual, they have released lesser amount, and out of 1 crore 48 lakhs, they have released 1 crore 14 lakhs. The 34 lakhs less. Why they will, after recommendation and verification, there is no reason or so-called or any notice why this amount will be deducted from them. Then, my lord, finding no out, they have approached this court that why this amount has been deducted. Then they file an affidavit, affidavit that it was affidavit that, my lord, the electrical component. Yeah, কোনো এফিডেভিট কি হলো ইয়াকে ফটোকপি করে পাই না তো এফিডেভিটখন দিয়াচোন এফিডেভিটখন দিয়া ক'ত পালা তুমি কিমান পেজ Yes, my lord, that this is page 127. They have filed the affidavit in opposition. Your lordship may kindly see page 129. Due to cash transaction. Page 129. Okay. Okay. Two affidavit. Okay. দেখাব লাগিব My bank to start notification. No, that money had to let us on it.
yes,
Actually, they filed 2-3 affidavit. There is a little bit confusion. Initially, in the first affidavit, they have stated that at page 129, paragraph 5, that due to cash transaction, I read it, that paragraph 5, page 129, that with regard to the statements made in so-and-so, the assigned deponent begs to state that SLC anonymously approve an amount of rupees 1 crore 14 lakhs only as eligible 30% Kenyan subsidy against admissible investment of so-and-so and release the sanction amount rupees so-and-so. It is to be mentioned herein that the SLC disallowed rupees so-and-so towards electrical installation due to cash transaction and not mentioned in the financial certificate. It is denied that the aforesaid amount was wrongly deducted by the respondent authorities, and it is stated that the cash component in expenses are not accounted in the cost factor and capital investment subsidy. So and so, so and so. So, my lord, their main question was, my lord, that it is paid by cash amount, that's why they have not released it. But in my reply, I have enclosed, that is at page 135, my lord. From the middle, I'm reading, my lord, that it is important to note that there is no payment in cash by the petitioner to any of the supplier of machineries and electrical instruments or any machinery
Okay.
components.
So,
as well
what
as-
is the, what do you want from this court?
No, I'm coming, my lord. They have misinterpreted the second, mainly they have misinterpreted the policy. That I'll place later on, my lord, because it was clarified when the association approached, final association approached the Ministry of Commerce, whether the electrical component is deductible. Otherwise, it was given a flimsy ground, and I have enclosed or submitted there all the financial transaction. There not a single penny has been paid to anybody in cash. So financial transaction place. Thereafter, they in other industries also they raise objections regarding release of the electrical component. Then the final, my lord, approached the Ministry of Commerce and Industry, Government of India. Then they clarified that these are
Where is it?
applicable.
Where
Yes.
is it?
Yes. So, my lord,
Where is the clarification?
yes, I'm coming to that, my lord. The letter here, it is my lord, the writ petition itself. And I have enclosed the copy of the letter at is. Sorry, I'm taking. Is at page 109, madam? Just a minute. No. It's not the- Just a minute, I'm unable to understand. Open it, open now. Ministry of Heritage. Well, I didn't have to do. Is that okay? Yes, 36. Yes, my lord, sorry. Page 36, my lord, Annexa 4. On 25th of February 2013. The letter is written, my lord, to the Principal Secretary Industries, Commissioner Secretary Industries, Government of Assam, so and so. Subject eligibility of components of plant and machinery for subsidy under Central Capital Investment Subsidy Scheme of Northeastern, so and so, NEIP, so and so. This refers to the notification issued by this department for Central Investment Capital Investment Subsidy Scheme, so and so, so and so, wherein components of plant and machinery eligible for subsidy under the scheme are defined. Subsequently, instructions have been issued by owner so and so, so and so, regarding competition of plant and machinery on the basis of the appraisal report of the financial institution which has funded the project claimed and subsidy above rupees so and so have been considered by the empowered committee on CCS number of cases. The committee examined the recommendation of the state level committee.
Madam, we can read 3 perhaps directly.
Yes, my lord.
3B.
Yes, yes, my lord. 3B. While miscellaneous fixed assets are not eligible component of plant and machinery for purpose of CCIS, however, electrical components essential for plant operation, which are connected on the plant side from the point where electric meter is put up to the point where finished goods are produced, dispatched, and are associated with the manufacturing process are considered as eligible component of plant and machinery for purpose of CCIS.
Okay.
This clarifies everything, my lord. That the component of plant and machinery for which payment has been made by cash by the industrial unit are not, that is not applicable for me because I have paid in all in my not check or demand draft or something. Based on the definition of transfer, provided a scheme notification, subsequent clarification, recommendation, so list of machinery and equipment here. They have given a copy to serial 6, Chairman Finer Guwahati. Serial 6, because they have approached for a clarification. Otherwise, my lord, without clarification, they have attempted to deduct that amount. And next page, page 38, here also plant and machinery for steel and rolling mill section wise. Mine says rolling mill, steel mill, my lord. Melting section, induction, finance and essential finance, electrical installation, gases, control panels, meters, water system, main.
Yes, sir.
My lord, the policy has been already placed, my lord.
Hmm.
Policy speaks about, my lord, giving some, my lord, subsidy in respect of capital investment in plant and machinery, be it a, my lord, new unit or a substantial expansion of the existing unit.
Hmm.
And my lord, by this clarification, this is the policy of 2007. my lord.
Hmm.
Now this clarification came in, my lord, 2012, 13,
13, yes.
base 36.
Hmm.
Now, my lord, the component of electrification work, my lord, while installing the plant and machinery,
Hmm.
that has been, my lord, incorporated within the meaning of plant and machinery by this particular
Hmm.
OMO notification of 2013. Our stand is this, my lord, though initially by the later dates, which is at page number, my lord, 31, the General Manager, District Industrial Commerce,
Hmm.
made an admission that
Hmm.
the amount admissible to the petitioner
Hmm.
for this, my lord, expansion of plant and machinery is, my lord, 1,48,90,000. Now, my lord, subsequently, my lord, in the SLC meeting held,
Hmm.
only 1,14 lakhs was thanked. The ground that we have cited, Lordship, has already seen para 5 of the affidavit, page 129.
Cash transactions.
Cash transaction.
And
Now,
electrical
why, my lord,
equipments.
cash transaction will not be admissible in this particular scheme, my lord, even though they have invested, according to them, in electrification of 34 lakhs.
Hmm.
That, my lord, I will place the policy. Lordship will have a look at it. Lordship will see, my lord, this is the Northeast Industrial and Investment Promotion Policy 2007. Under this, my lord, in the next page, in the content page, Lordship will see various schemes are there. Number 2 is the, my lord, Central Capital Investment Subsidy Scheme 2007,
Hmm.
which is applicable in the present case.
Hmm.
Now, Lordship will see down below. 6, notification on operational guidelines. Every scheme has got its operational guideline. Lordship will now turn to 6B, page 38.
Hmm.
I have taken the printout, my lord. Page 38, last second page of the plan.
Yes.
General operational guidelines for registration of so-and-so. Lordship will see here point number 14. Quote from below. All transaction in respect of the cost of plant and machinery. My lord, by this 2013 notification, electrification is now under plant and machinery. All transaction in respect of cost of plant and machinery project, as the case may be, must be through section demand draft only.
Hmm.
So this is our case, my lord. Case transaction, we have found that entire, my lord, 34 lakhs was done by case transaction without there being anything to show that, my lord, it was done by check or demand draft. Accordingly, that amount was deducted as per the, my lord, policy. There's a case, my lord, whole case. Not that, my lord, we have
Can we just have one thing?
Yes.
This page 167. Or let us just have a look at this one, page 142.
Well. Second book. Running page.
142. Their affidavit in opposition.
Affidavit filed by madam.
Affidavit in reply.
Reply.
Actually start from 138 panel, all bills which originals I have deposited there.
In
Bills
this,
from 138, what are the companies there?
Madam, page 133. Affidavit in reply, do you find?
That.
It may be marked as 145 also. Yes,
Yes,
that is the affidavit
Yeah.
I'm talking about. What does it start at?
It's the para. Yeah,
No, it starts at
reply. Page 140, running page 145.
145. It is shown 145 there. Here
Yes.
it is 133. Okay.
Plot.
Then if you come to page 154,
Right.
it is by draft. Can you see? Brahmaputra Concrete Pipe Industry.
Yes. Money receipt. It's in the draft.
Receive with thanks from so and so, sum of rupees so and so by draft is ticked up
No,
with
demand.
the number.
Well.
By a number
My lord.
670229. So that is a draft number. Then if you come to page 140, 156, check number. Do you see?
But if-
No. Received with
Some-
thanks from message. It is from Ramesh
Yes,
Agarwal.
yes, thanks from MS. Yes,
Only by check number. Is it?
by check number.
Ah.
Yes. Fine.
Then, if you come to 146, again,
Right.
sorry, 148, 158,
My lord.
158, DD number,
No, DD number.
is it? By DD number 670693, last line.
Ah.
Then on page 160, you'll find a check. Now, petitioner's assertion is that all the money had been paid by this mode.
Plot.
We will not look into that.
That's why if you have to.
Since there is a clarification now that for all electrical equipments,
Yes.
which can be included into the scheme,
Plot.
they are required to be given the benefit.
Well.
We will refer the petitioner
Yeah.
to the department.
Plot.
She will place all relevant documents before the department.
State level committee will again take that.
Whichever, to the competent authority who will go
Yes,
through all this, find out if it was wrongly deducted. If wrongly deducted, she gets the benefit. If not wrongly deducted, then you let her know that this is the reason, this is not matching with that. You are asking the subsidy for this electric pump,
Yes.
and that has not been paid for in check.
So Lordship may see page 155 for a moment.
155.
I may be wrong, my lord, but Lordship will see 155.
Ah.
Ramesh Agarwal,
Hmm.
do so and so, being the transportation charges including loading, unloading and labor charges.
Mhm.
My lord, this will come in there.
Huh.
10,000.
Possibly, it may be a case.
For the electrification, it is, well, that will come in by 2013. This is a bill relating to transportation.
That
charges,
is-
loading, unloading.
That
They
is
will examine.
that is what I'm telling you. We will not look into that. Why should we break our heads on that?
Yes, yes. my lord. Okay.
Let it go before the committee. Committee will see whether it is a costing for the
Yes.
putting up the electrical motor or not.
My lord.
If not, reject it.
Lot. And they will place the evidence, my lord, of that 34 lakhs.
They will approach the competent authority with all the documents that they
Not-
have. But prior to that, you have to tell them what amount has been deducted, which of the
34,
amounts.
it's there, my lord, in
No,
the
no, no,
list.
no. 34 lakhs is deducted.
My lord.
34 lakhs relating to which of the payments? Someone gave them a certificate saying that she's entitled to 4 crores something 30% out of it, 1 crore something, they will,
40 lakhs 90,000.
you reduced it to 3 crores,
My lord.
3 crores something.
My lord.
That 1 crore was deducted. Which part was deducted? She has to be told.
But we have
That
said it
this
in a
1
affidavit.
crore-
We have said it in a
No,
clarified.
The particular amount which has been deducted, that this bill has been deducted has to be told.
There's the amount. Directly, if it is subtracted, my lord, whatever amount is now released, it goes to my lord 34 lakh,
We,
34, 48,
when you are saying the round figure, we understand
Lord,
that it is calculated somewhere.
my lord.
That calculation breakup she has to have so that she can give the appropriate documents to support that
Lord,
was wrong. That is what I'm telling you.
Point.
That breakup has to be given to her.
No, that civil approach, my lord, they will find it. Lord, lord.
May I
Yes, madam.
respectfully submit that, my lord, in each and every case, if there is no direct order, they pass picking order. Earlier also, another
If
pending for
matter is-
judgment,
Or
half
what-
judgment is given, I have to come twice and again.
No, what
In
is the-
each and
what-
every case, they pass picking order.
What
Then
is
I
the
will
direct
accept
order?
it.
What is the direct order we can give you? Kindly tell us.
Direction, my lord, if your lordship is having any doubt, their officer should be present along with the original receipt, what we have submitted before them. Then, my lord, he
And
will
then
admit
we
and
will-
your
then-
lordship can pass directly.
we will- then we
Money
will-
should be amount.
Then we will sit down here and we will compare
No,
the
no,
receipts
compare.
and
He will compare and he will just submit, yes, my lord, these are the original, because we have given the photocopy. And my lord, what happened? What happened? If a direct order is not given, they pass speaking order. Each and every case, so many industrial cases I'm doing, again I have to come again. That is the harassment. But this case is the application was done in
if
2008.
you had
2008.
if you had approached a forum which could have looked into all of these bills and taken evidence, you would have had a direct order. When you approach this court saying that there is a violation of some constitutional right, we
That
can
is
only
why-
give an
because
order
at that
regarding
time,
the.
initially, they have rejected my claim for dual benefit, taking dual benefit.
Would you like us to pass an order
Yes, as your lordship, your lordship
uh,
will ensure that I need not
requiring
come
you-
again and approach this.
requiring you to put up everything before then? These documents along with the deduction that has been made,
Keeping it pending also, your lordship can direct that, my lord. Otherwise.
then you have to go before somewhere else.
That's my lord, as your lordship pass an order, then if no direct order, you should, how much harass my lord, 2008,
Not the case.
since 2008, I'm been in court. 2008, we have passed the application, filed the application, thereafter, my lord, 3-4 times,
See-
again writ appeal, twice they have filed writ appeal.
Madam, you first had a writ petition here. In that writ petition, you
is
challenged
allowed-
only the
Dual
rejection
benefit,
of the
dual
claim.
benefit,
Huh.
initially dual benefit.
In that case, you did not get it decided whether this deduction was correct or not. This court has
At-
passed an order requiring the respondents to pay the admitted amount. You did not dispute any amount.
At that time, my lord, payment was not,
You did not
come-
dis,
come, my
at
lord,
that point
because
of
they-
time, you did not dispute
entire
it.
payment, they have disputed that.
Yes, take down.
What benefit?
Shall we dispose
First,
it of?
yes, my lord. First, my lord, let me clarify few points only.
Hmm.
First, the petition was filed here, challenging that, my lord, they were saying that I have taken dual benefit.
Hmm.
That has been decided by Honorable Justice Ujjal Bhuiyan.
Hmm.
The dual benefit also you can give, you have to give. Then they filed writ appeal, stating that we are not allowed to file certain documents. Then, my lord, again it was remanded back.
Hmm.
They did not file a single piece of paper. Writ appeal was, my lord, then freshly it was decided. Again, they have, when the court decided, again they went for writ appeal. Writ appeal was dismissed. Again, my lord, I have to come because my money has been deducted. Then, my lord, the electrical component, they have stated in affidavit, they have not stated any reason why they have been, initially have submitted why my money has been deducted, or any show cause, or any notice, they have not submitted anything. They simply deducted without giving me a chance to clarify it. Number one. Number two, first affidavit, they said that cash transaction. Second affidavit, they stated they have filed 2 affidavit in opposition. First, when my lord, honorable court has stated no, they have filed all the requirements, all this comes into this. Then they were allowed again to second affidavit in opposition. Second affidavit in opposition, they have stated the electrical components are not entitled. Then when I submit this, all this done, my lord, now it is up to hearing. And judgment was reserved. After 6 months, it was released again. Because he has been transferred. So your lordship will see so that a clear order is passed and I need not approach the court again. Because it's a harassment for the citizens.
Where is that order saying that cash transaction part, they should file another affidavit?
Order sheet it will be, my lord. Then the second affidavit was filed. When that point was order cited, this person put the order as well. Maybe long back, my lord, 2 years back.
That additional affidavit, where is it? Clarificatory affidavit?
Affidavit position again they have filed. Court said that, my lord, since there is no cash
What's the
transaction.
clarification given?
Second affidavit is, my lord, regarding electrical installation. Additional affidavit of opposition filed on, my lord, at page 186. Filed on
Hmm.
18/8/24.
Hmm.
Here they have said that
Mr.
additional
Gogoi.
affidavit of opposition.
This clarificatory affidavit, do you have it at page 187?
My lord.
Para 3?
One,
Perhaps.
it is
88, paragraph on 88. The fact that the affidavit, it has been mentioned that SLC has disallowed so-and-so towards electrical installation due to cash transaction. However, after proper verification of the documents, it is seen that rather than the aforesaid, it should have been the SLC has disallowed so-and-so towards electrical installation. It is submitted that a subcommittee was formed to examine the claims of 30% CCIS valued more than 1 crore, and the subcommittee has accordingly recommended the omission of the expenditure
Do
made
you have
by
the second
the.
copy? Yes, madam, just one. Do you have the second copy of the writ?
I'm.
You have that copy, na? Second copy?
Yes.
Please come to page 129.
129 I've seen, para 5.
Para 5.
Yes.
It is to be mentioned here that the SLC disallowed so-and-so towards electrical installation due to cash transaction. Do you see?
Love it.
Para 5 in the middle.
Yeah, that I have seen.
129.
Due to cash transaction?
Yes, sir.
Now please come to page 187.
Okay. Some paging number.
Okay, but the next affidavit file, it is 184 perhaps.
But it is filed, that affidavit filed by my lord Topon Dega.
Topon Deka
Yes.
on 28th of August.
Lord.
Now he clarifies. It has been mentioned, para 3.
Right.
It has been mentioned that SLSC disallowed rupees Iman towards electrical installation due to cash transaction.
Hmm.
After proper verification of document, it is seen that rather than the aforesaid, it should have been SLSC disallowed so-and-so towards electric installation. The term cash transaction has been taken away by this additional affidavit while clarifying the issue. So the cash transaction part had been given up by this additional
No,
affidavit.
Lord, you will see, my lord, may I continue, my lord?
Oh, yes.
It is submitted, my lord, page in my para 3, my lord, last time, it is submitted that the subcommittee was formed to examine the claims of 30% CIS value, valued more than rupees 1 crore, and the subcommittee has accordingly recommended the omission of expenditure made by the claimant against electrical installation and case expenditure which they approved by so-and-so in their meeting held so-and-so. Further amount of so-and-so was deducted by the organization from the amount of plant and machinery recommended by GMTS due to vulnerability of payment.
Now, when you say that this cash transaction is removed in the affidavit, now I can also give you the order. I do not know whether there is a copy there. There is an order here which says that
Sure.
this additional affidavit is filed
Sure.
because
24
a mistake may have a 24/7 years. Therefore, he would like to file a clarificatory additional affidavit as according to him, such mistake will have a ramification. So that cash transaction has been removed by this additional affidavit. Once the cash transaction is gone, it is the only ground that remains is the plant and machinery, that electrical appliances.
My lord,
If that be so, and electrical appliances is now included by the 2013 clarification. Clarification being retrospective has to be paid.
right. My lord,
Yes.
Lordship will quote this para 3, my lord, in the affidavit. What
You have
will
to.
say it? I have not seen.
We have to, because you have removed that
Yes,
cash
yes.
transaction part. Whichever way we try to read that para 3, it cannot include the cash transaction part.
Recommended the omission.
Ah.
Only thing, my lord, the 18,000 will remain. Last,
18
They have not-
30% she does not require. That 6,000 she will let go.
Lordship will, my lord, quote this particular para.
Will do.
Because since, my lord, it has been clarified by the same authority.
Heard Miss Ansakil and counsel appearing for the petitioner also heard.
Lordship, on behalf of respondent number, Lordship told Lordship, it was a nodal agent, we have no role to play. Our role come after the claim for submitted by the state government, funds being provided to us. That's our role.
People like.
Heard Miss Ansakil and counsel appearing for the petitioner also heard Mr. B. Gogoi learned counsel appearing for. Yes, Mr. Gogoi. Discussions a little later. Can you help us?
Lordship, all the status,
You are appearing for
my lord, respondent 2, 3,
Hmm.
2 and 3.
2 and 3, Mr.
And 5.
So-and-so.
2, 3 and 5.
5. Mr. So-and-so, yes. Jidas appearing for respondent number 4. Union of India, madam. Can you appear? It is your policy only.
Yeah, yeah, police.
Miss B. Sharma for
1, respondent.
respondent number 1. This writ petition has been referred by the petitioner under Article 226 of the Constitution of India, being aggrieved by the action of the respondent number 2, 3, and 4 in rejecting the claim of the petitioner for subsidy under the Central Capital Investment Subsidy Scheme 2007, whereby the respondents have deducted a sum of rupees 34,48,453 from the total subsidy which the petitioner alleges to be entitled to. Full stop. The petitioner company is engaged in manufacturing TMT bars and rods. Full stop. With the introduction of the Central Capital Investment Subsidy Scheme 2007 under the NEIIPP 207.
I have prepared a bunch, my lord, of the cases. As per your lordship can see. That was, they are submitted, but it is missing from the file, my lord. It is just,
Mhm.
just it. You can have a look.
Yeah, we don't need all so many judgments. Why should we take down so many judgments when we can go on facts? Yes,
No,
did you say?
particularly, my lord, there is a decision of.
We'll record,
Where, my lord,
we'll record your,
when a policy decision is taken, when a particularly the 2005 decision, that the schemes have to be construed with practical and pragmatic approach so as to achieve and not frustrated the purpose sought to be achieved. The application should not be dealt with a hyper technical approach or in the pandemic manner. That is very important because with some long to the scheme, announce the scheme, if the technical ground, on some technical ground, they frustrated the scheme, That is my answer, unfortunate. That's why the decision is very.
What did we say with the introduction of the under the NEEIP 2007 through a notification dated 27/7/2007, comma, the Government of India announced that all eligible industrial units located anywhere in the NER Northeastern region shall be given a capital investment subsidy at the rate of 30% of their investment in plant and machinery or additional investment in plant and machinery. Full stop. Such subsidy would be applicable to units in the private sector, joint sector, cooperative sector, as well as the units set up by the state governments concerned in the Northeast region. The duration of the scheme was from 1st of April 2007 and it would remain in force up to and inclusive of 31/3/2017. Full stop. The petitioner company, having made substantial investment in the plant and machinery of its units, of its production units, comma, it applied for grant of the subsidy in accordance with the scheme, and by a communication issued by the General Manager, comma, District Industries and Commerce Center, Tinsukia, on 24/12/2006, comma, the Director of Industries and Commerce, Assam, was informed that the admissible amount of investment in plant and machinery for the particular unit of the petitioner came to rupees 4,96,33,335 only, and the 30% CCISS recommended to the unit was stood at rupees 1,48,90,000 only. Full stop. In a meeting held by the SLC, comma, an amount of rupees 1,14,41,547 was taken by the SLC to be the amount which would be considered for granting the subsidy under the scheme, and accordingly the petitioner company was held to be entitled to 3,81,38,493 rupees of subsidy. Full stop. When the payment of the subsidy was not made to the petitioner, comma, the petitioners had approached this court and the stand taken by the respondents in the writ petitions and writ appeals filed subsequently, where that the petitioner and other similar companies would not be entitled to the subsidy since allowing such a subsidy would be allowing them a double benefit under what? Benefit both under the SPINE scheme and the CCIS scheme. Full stop. This court, in the finality, had decided that the petitioner's hearing would be entitled for the grant of subsidy under the CCI SS 2007 also. Full stop. The details of the previous litigation, comma, which do not have a bearing in the present list are not being discussed in details, save and except that the petitioners were held to be entitled to the grant of the benefit under the CCISS scheme, comma, 2007. Next para. The petitioners claim that they have been paid the amount of rupees 3 crores 81 lakhs 38,493. Full stop. The grievance raised in the present writ petition is that although the recommendation in favor of the petitioner was for a subsidy of rupees 1 crore 48 lakhs 90,000, comma, on the basis of a total investment of rupees 4 crores 96 lakhs 33,335, comma, the respondents have calculated the amount of rupees 1 crore 14 lakhs 41,547 as approved CIS on a basis of an investment taken at the taken to be rupees 3 crores 81 lakhs 38,493 only. Full stop. Next para. Ms. N. Saikia, learned counsel appearing for the petitioner, has referred to the provisions of the subsidy scheme and the earlier orders of this court to impress that there is no doubt that the investment made by the petitioner company in its, what do you call it, what and machinery? PNN, plant and machinery, are entitled to be considered for grant of the subsidy under the scheme. Full stop. Ms. Saikia has submitted that the only ground on which the investment has to be taken at a lower figure than what was approved by the district authorities is that the electrical appliances, electrical component, what do you call it? Electrical, the electrical installation was considered by the state respondents to be not eligible for consideration for payment of the subsidy. Full stop. The learned counsel has drawn the attention of this court to the affidavit in opposition filed by the respondent number 2, 3, and 5 on 25th of April 2024, where at para 5 the following has been stated. Please take from page 129, para 5. Okay? The learned counsel has submitted that in the affidavit in reply, the petitioners had given substantial evidence of the fact that there were no cash transactions involved in the electrical installations, and therefore the stand of the respondents that the subsidy could be refused on the basis, on the allegation of cash transactions being involved was baseless and requires the interference of this court. Full stop. She has also drawn attention of this court to the additional affidavit filed by the respondent number 2, 3, and 5, where at para 3, the following is stated.
Keep the date, man.
Huh?
We will keep the date of that. 28.
Ha, in the additional affidavit filed on 28th of August 2024, where at paragraph 3, the following is stated, huh? Paragraph 3, here, page 187. Huh? Full stop. The learned counsel has submitted that with the correction sought to be brought in the earlier affidavit, comma, the allegation of the respondent authorities that it was due to cash transactions stand belied, and it is apparently that the SLC had disallowed rupees 34,48,453 towards electrical installation only. Full stop. The learned counsel for the petitioner has thereafter drawn attention of this court to the clarification issued by the Government of India, Ministry of Commerce and Industry. The clarification dated 25th of February 2013, issued by so-and-so, huh? Where the following has been clarified. Para 3 at page 36. Para 3, A, B, and C, huh? The learned counsel for the petitioner thus submits that it is now settled and clarified that electrical components essential for plant operation, which are connected to the plant site from the point where the electrical meter is set up to the point where the finished goods are produced or dispatched and are associated with the manufacturing process, are required to be considered as eligible component of plant and machinery for the purposes of the CCISS full stop. She does praise for a direction to the respondent authorities to pay the balance recommended CCISS amount of rupees 34,48,453 only. Full stop. She has also prayed that the petitioner company would be entitled to 12% interest per annum for illegally detaining the subsidy amount. Full stop.
That MSME Act also, because these are registered under MSME Act, medial and.
We are not giving any interest. We are not allowing any interest.
But-
We are
but,
just recording your prayer. Yes, Mr. B. Gogoi, learned counsel appearing for the respondents number 2, 3, and 5. Why is it 2, 3, and 5?
Yeah.
2, 3, and 5. No, prior to that, right, Mr. So-and-so appearing for the respondent number 4 has submitted that it is only a disbursing agency for the subsidy amount if the same is released in favor of a industrial unit by the respondent number 2, 3, and 5. Full stop.
By the Union of
By the if the subsidy amount is approved by the respondent number 2, 3, and 5 and released by the respondent number 1.
One.
Full stop. Mr. B. Gogoi, learned additional advocate general appearing for the respondent number 2, 3, and 5 has drawn reference to the affidavit in opposition filed on behalf of the state respondent to submit that the subsidy for electrical installation by existing or new units was not specifically a part of the scheme of 2007, and it is only by the later clarification of 2013 that it has been clarified that electrical installation as described therein would be eligible for grant of the subsidy. Full stop. Therefore, at the initial stage when the said subsidy was rejected, there was no infirmity by the no infirmity in the decision of the SLC, full stop.
Misinterpretation.
Hmm?
Actually misinterpretation. Then my association approached them to give the clarification. It was a misinterpretation by the authority. So some of the units are given, some of the units are not given.
Madam,
Yes, madam.
in earlier
Listen
occasions,
to the court.
please listen to me.
Yes.
In earlier occasions, when I was interrupted in between orders, I had the order struck out and had the matter listed after 3 or 4 weeks.
My lord.
Should we do that? Please do not disturb us. We are trying to find out a solution to the problem. We had heard you. We did not stop you.
Yeah, sorry about.
Please do not. Yes, Mr. Gogoi, anything else that we need to record?
One more thing I'd like to point out, so
Huh.
far as the petitioner's claim is concerned, it was already considered in the meeting of 2010.
Hmm.
Clarification came in 13.
Hmm.
Even though she finally got the amount in 2021 after the repeal order.
Hmm.
For the second time, it
Hmm.
was dismissed. But my contention will be that, so far as the decision was.
That is what I've said. That is what I've said in
Subsequently
2007.
clarified.
Even subsequently, when the matter was reconsidered,
Yes.
comma, even at that point of time, the clarification was not available with the respondents, and therefore no fault can be found with the decision taken to deduct that particular amount, full stop. Mr. Gogoi has, however, now when confronted with the contents of the affidavit filed on 28th of August 2024, Mr. Gogoi has, however, submitted that the same clarifies that it was not due to the cash transactions. It appears that the rejection was not due to the cash transactions, but only because the electrical installations were held not to be entitled for the grant of subsidy. Stop. The submission, the records available with the writ petition have been perused, and the submissions made by the counsels for the contesting parties has been duly considered. Full stop. This we will add later on. This judgment part will where the petitioner, where Ms. N. Saikia had made that this thing, submissions. Ms. Saikia relies upon the following judgments to buttress her submissions. Which was that particular
Yes, my number 2, 2005 10S.
2005? She has in particular stressed upon the judgment judgment delivered in the case of Under Secretary, Minister of Industries and others versus Marcon Textiles Industries Limited, reported in 2005 10 SSC 554, wherein it was held as follows at para 8. Huh? You take this. I've picked it up. Huh? Then the submissions made by the learning council for the contesting parties have also been considered. Full stop. It is apparent and an admitted position that the petitioner was denied the consideration of the electrical installation made in the industrial unit from consideration for the eligibility of the subsidy, since the respondents were under an impression at that relevant point of time that such electrical installations were not eligible for being considered for the purposes of calculating the subsidy. Subsidy, full stop. The clarification dated 25th of February 2013 is not in dispute, and therefore the position is now clear that subsidy would also be that expenses on electrical components essential for plant operation and which are associated in the manufacturing process are also considered as eligible component of the plant and machinery for the purposes of the subsidy. Full stop. Since the only ground taken by the respondents to disentitle the petitioner from a particular part of the subsidy has now been put at rest by the clarification issued by the central government, this court deems it fit to remand the matter to whom? To the respondent number 2.
State level committee.
To the respondent number
Lordship will send
2.
2, 3 and 5 men. They will.
No, we'll send it to one person. He will refer it to the SLC. Just tell us whom.
Then Lordship will refer it to the Industrial Department.
To the respondent number 2.
Right.
Commissioner and Secretary,
Commissioner.
Industries and Commerce Department.
Yes.
To the respondent number 2, who shall call for the records of the claim placed by the petitioner. And place the entire records before the state level committee for reconsideration of the rejection, which was based only on the ground that the electrical components would not be entitled for the subsidy. Full stop. In case the records of the claim placed by the petitioner is found to have been reflects that the case was rejected only on the ground that electrical components at that time were understood not to be eligible, the state level committee shall take into account the clarification issued by the central government on the issue and reassess the subsidy to which the petitioner will be eligible. Full stop. In case the petitioner is found eligible, the payment, subsidy shall, recommendation shall be forwarded to the concerned authorities, and the subsidy and the respondent number 1, 2, and 4 shall ensure the payment of the subsidy to the petitioner within a period of 4 months. 4 months
Yeah.
from the date of receipt of a certified copy of this order. Full stop. It goes without saying that in case the SLC comes to a conclusion that the petitioner would not be entitled for the subsidy on the electrical components, the detailed reasons thereof shall be intimated to the petitioner, who shall be at liberty to agitate her grievances, if any, by resorting to appropriate proceedings. Yes, madam. Anything else?
Nothing, they will pass a speaking order.
No, they will not pass a speaking order. We have said that it is the electrical component. If that was the only ground of rejection, then they have to
Yeah.
pay you within 4 months.
Maybe 2 months or 3 months before March.
No, Lordship will
They have
make
to
it
take a
matter-
decision. It has to go to the central government. March ending is coming.
They are very prompt. In the
Well,
last
4 months from the decision.
in
of the-
4 months from the
September,
date of,
permanent,
months from the date of
while they issue.
receipt of the copy. Why?
Yes.
In filing the writ petition in 2013,
I understand.
clarification was already there.
Then Lordship will make it 1 month for the SLC, 3 months for the payment.
For
At
the,
least they have
no,
to-
for the
SLC?
entire thing, we have given 4
2
months.
months.
Whatever time you take,
Not-
1 month,
SLC,
wherever-
yes, my
whatever
lord.
you
If
take.
his suggestion,
If we break it up,
his suggestion may help
then
me.
one
my
by
lord.
one contempts will come. If we give a consolidated, it is one contempt.
But Government of India is very prompt, my lord. In month of September, within 1 week after receiving the notice, they have sent the amount to their account into Tea Garden. So like this, here, my lord, my God, They will take, after 6 months, they will pass the speaking order. It's like,
We have not allowed them to pass a speaking order. We have said that if it is the only ground, they will pay you. If there's any other ground, okay, you take down one more
It is
sentence.
like 3 months, my lord.
Beach में एक sentence, Mr. Gogoi, we are adding one more sentence to the order. Beach में we'll put it somewhere in the middle. The respondents have not projected any other ground for rejection of the claim of subsidy while contesting the repetition.
I'm like, I hope so.
Item two,
Repetition disposed of. Yes.
May I please, Your Lordship? Lordship, I am appearing on behalf of Mr. Esnath. He is not well.
Mr.
Esnath for LIC.
Yes.
He is not well. Kindly,
Huh?
Lordship, kindly the matter pass for 40 days.
2022 fixed. What is the matter about, sir?
So we are challenging a recovery order
Ah,
passed by the estate officer.
hmm,
Now, under the Public Premises Act.
hmm.
Now, that order was passed holding his proceedings at Kolkata in respect of the suit property in Guwahati. We are assailing that.
Hmm.
According to us, he has no jurisdiction to hold the proceeding at Calcutta. Law is settled. It should be where the subject property is situated. But even otherwise, even yesterday he informed me.
So your argument is that a person sitting at Kolkata would not be
No,
authorized to pass an order with the property with regard to a property which is situated in Assam, even if he is declared to be the estate officer.
absolutely
For that
no
property.
dispute that he is the estate officer.
So who does it here then?
He will do it,
Huh?
but holding his proceeding where the subject property is situated. That is the law laid down by the Supreme Court. So even otherwise, Malad, that
Okay.
since a prayer has been made, even yesterday he informed us.
But Mr. Nath Leonard Council is paying for the petitioner. A prayer has been made on behalf of Mr. S. Nath, Leonard Council appearing for the respondents that he is not in a position to appear today and that the matter may be taken up after.
Vacation. After vacation.
In the interim, Malad, interim will continue earlier.
It's a 2022 matter. Maybe taken up after, maybe taken up on a later date, full stop. List this matter again on 20th of January 2026. Full stop. The matter is of 2022 and it is clarified that an attempt would be made to dispose of the petition on the next date fixed. Interim orders passed earlier shall continue.
item three,
On January 20th, we will not adjourn it again for whatever reason. We'll take it up for decision. Yes.
May I please, Your Lordship? So learned counsel with the petitioner Mr. M.A. Wilson is out of station. My lord.
Hmm.
Due to some personal emergencies,
Hmm.
he had to go to Dehgaon early morning.
What is the matter about, sir? What is the matter about?
Lordship, the petitioners were allotted 3 shops in the Balukdubi supermarket.
Hmm?
In the Balukdubi supermarket,
Hmm.
petitioners were allotted 3 shops for opening pharmacy.
Hmm.
And which was nearby the Balukdubi Civil Hospital, Your Lordship. And between their shops and the Balukdubi Civil Hospitals, there was a government plot which was allotted to respondent number 8 for opening a school for handicapped children and a child development center. But they are now using that plot of land for commercial purpose, Your Lordship.
Yes, circle officer.
This fellow there file an affidavit in his favor.
What is the stand?
Fellow para 4, page 61.
Behalf of affidavit on behalf of respondent number.
Circle officer.
Why do I not? Yes. Respondent number 5.
Chalo.
Respondent number
Five,
5 now.
five.
You have to take care, sir, this, the index. It is writ petition, affidavit with annexure.
Yes, yes, sir.
And that, the index is wrong, everything wrong. Yes. What have you said?
The pair of 4, page 61. That we regard to the advertisement made in the pair of 5, the writ petition, it has been seen the land covered by dock number 193 in Revenue Village, Al to be number 2 Jungle Book under Palizana Revolutionary is recorded in the name of the district civil hospital. It is to be mentioned herein that a notice has been issued to the board parties for hearing, that is Noor Abbas and 10 others, along with Solendas, Secretary of the State issue Vikas Kendra by mentioning the dock number 193. But as per the document submitted by the Solendas during the, it reveals that the area of land measuring 2 biga out of the total area. So 12 biga 2 quotas 19 lesser covered by dock number 194 is settled in the name of Sisu Vikas Kendra. And this dog is adjacent to the dog number 193. The 194 is erroneously omitted in the hearing. Notice due to the clerical error. My lord, if your lordships come to again to the para 6, page 62. The deponent below 1 mile below. The deponent further stated hearing has taken at a later stage on the basis of the petition submitted by the petitioner, and report of the said hearing was submitted to the district administration, Goalpara. If a lordship come to the report, my lord, that is it.
Who appears for respondent number 8? Madam, this,
We have
at-
filed an affidavit, Lord. We have
at
neither,
page 65, there is some notice to you.
Lord, I do not have a copy of the affidavit filed by my learned friends. If I-
Okay.
No,
Sir,
this is the Child Development Center, Your Lord.
Yes.
I am appearing on behalf of respondent number 8, which is Shishu Sarati and NGO, Your Lordship. We are only run the outreach program. We are neither concerned with the land nor has the land been allotted to us. It has been allotted, if at all, it has been allotted, I do not know. It may have been allotted to the respondent number 9, not to the respondent number 8, Your Lord.
This Child Development Center is not.
It's not, this is not me, Your Lord. Your Lord, kindly peruse the array of parties. We are Shishu Sarati, which is an NGO from Guwahati. We only run an outreach program in collaboration with the respondent number 9. So the respondent number 9, whether they have been allotted that particular plot of land is something I am not aware of, Your Lord.
Then was elected for some other purpose, and according to them, a commercial activity is started.
It's not commercial activity. It's a philanthropic kind of a thing.
So far, respondent number 8 is concerned.
Yes,
If you are saying that you are not, you have not been involved in that
not at all, Your Lord.
construction,
And that is clear from my affidavit.
yes, we'll take into account that.
Your Lord.
What about 9? Yes.
Application by the civil court. Accordingly, this case was withdrawn earlier, and the petition was disposed of by the appropriate court. And that effective applications has also been filed by the respondent number 8.
We had raised subjects by affidavit, but subsequently they have filed a petition. That's that on the earlier occasion, the cause factor was cited, and now the cause.
Now they are agreed by the state not taking any steps.
Yeah. They have clarified that by the objection.
You don't have any affidavit on record. So we will allow the writ petition unless you can show proper documents to these district authorities for allowing the construction. If you made any construction, appropriate sanction will be issued against you
My lord,
for constructing without permission and all that. From 2023, how much more time do you require? When were you, when was notice served on you?
Page 65, my lord. Page 65 of my,
Already the department is saying that you are not authorized to make that.
as per
Construction.
instruction, you are directed to stop the construction work immediate.
Whatever is constructed, remove that also. By when? We are very impressed if you are trying to do something for the society. But then it has to be done. That is the only thing.
Page 64, my inquiry also says that state land was allotted
go-
with a vision for
the-
educational purpose.
The government is saying that you are misusing the land. Within? This is a writ petition. Pending from 2023, where the office notes, where the proceedings of the Law Azima Court of 962023 reflect that the respondent number nine had been completed. Full stop. When did you enter? When did you file your wakalatnama? Have you filed your wakalatnama, sir? Huh? When? File kon DD action second file to DD. Wakalatnama ketia file korisil? The respondent number 9 had entered appearance by filing their wakalatnama. Full stop. Affidavit in opposition on behalf of the respondent number 5 and respondent number 8 is available on record. This affidavit by respondent number 5 will cover for 1, 2.
My lord, 2 and 3, my lord.
It will cover for
2, 3, my 2, 3, 5. 2, 5, 2, 3, 5.
2, 3, 5.
1, 1.
For 2, 3, 5. Full stop. The prayer made in the writ petition
1 is secretary, Panchayat.
is for okay, we'll come to that. The writ petition was filed praying for directions to the respondent authorities to interfere in the shop constructed at Bhalukdubi covered by DAG number 183 on a plot of land covered by DAG number 193 adjacent to Bhalukdubi supermarket. Full stop. The pleadings on record reflect that the circle officer of
Circle officer, my lord.
Balijana,
Revenue circle. Revenue village.
Balijana Revenue Circle,
Yes. Golpara.
Gwalpara, had issued notices to the respondent number 9
3/12/2020.
requiring them to stop construction works immediately at the Bhalukdubi Child Development Center. Full stop. The respondent number 9 has filed, respondent number 8 has filed an affidavit stating that the respondent number 8 had extended its early intervention services through an outreach program for children with disabilities and their families in Gwalpara in agreement with the respondent number 9. Full stop. However, the respondent number 8 submits on the affidavit that it is not connected with the construction, if any, being undertaken by the respondent number 9. Full stop. The respondent number 9 had entered appearance in September 2024. And today, when the matter was taken up for consideration, a prayer has been made on behalf of the respondent number 8, that respondent number 9, that they may be allowed to file an affidavit to bring on record their response to the writ petition. Full stop. This court is of the view that the respondent number 9 is attempting to delay adjudication of the matter. Full stop. As a last opportunity, the respondent number 9 is allowed to bring its response on record on or before 19th of December 2025, list this matter again on 22nd of January 2026, by which time the other contesting parties will be at liberty to bring on record or to respond to the affidavit, if any, filed by the respondent number 9 or by any of the other contesting parties. Full stop. The matter, an attempt shall be made to take up the matter for disposal on 22nd of January 2026. Yes, this kind of delaying tactics we do not appreciate. There is no difficulty. All bring it, kindly have it brought on record by filing your affidavit. Is it not? There is no difficulty, sir. It is your presence which has got you time till December 19th.
Item 4,
Yes.
Please, your lordship.
Yes, madam.
Lordship, I'll start, my lord. Lordship may kindly have a look to the, my lord, the RERA Act, my lord.
Do you have anything to show that we can waive that part? No.
My lord, I can read. No, no point.
Just a minute. Will you
My lord, I'm taking your lordship to the definition clause.
just a minute, ma'am. I
Ma'am.
think he's looking for the act. No. Yes.
My lord, lordship may kindly come to the definition, section 2,
Section 2, yes.
ZK, which defines the promoter.
K.
K, ZK.
Yes.
A promoter means a person who constructs or causes to be constructed an independent building or a building consisting of apartments or converts an existing building or a part thereof into apartments for the purpose of selling all or some of the apartments to other person, and includes this assigning or a person who develops into a project, whether or not a person also constructs structures on any of the plots for the purpose of selling to other sellers and some of the plots on the state project. Now, my lord, where I am stuck up in this case is that, my lord, regarding payment of the pre-deposit. Lordship may kindly turn to now page, the section 43. Section 43 is the provision for appeal.
3. Just a minute.
43 is subsection 5.
Even this is going slow.
Anyway, my lord, may I read out?
Please.
Any person aggrieved by any direction or decision or order made by the authority or by an adjudicating officer under this act may prefer an appeal before the appellate tribunal having jurisdiction over the matter, provided where promoter files an appeal. So when the promoter files appeal, then only the clause will apply.
Hmm.
The appeal application shall not be entertained without first having deposited with the tribunal at least 30% of the penalty.
Hmm.
So here in this case, my lord, by way of that agreement, which is still in force,
Hmm.
the entire project has been transferred to a new promoter. So I am no longer a promoter to be sued as a promoter in proceeding before the RERAM. Lordship may kindly come to the agreement.
You are trying to say that you do not fit into the shoes of a promoter
No,
when you file this appeal, and therefore the
my contention before the authorities were that it has already been transferred. That was not taken into account by the tribunal, and this fact that entire project has been transferred, possession has been handed over. I have nothing to do with the project thereafter. This was completely ignored, and therefore filing appeal, I'm not a promoter. So filing appeal by myself will not attract this provision. And this issue was not decided by neither the tribunal nor the appellate authority. Although it was on record that the entire project was transferred during the proceedings, and the claimant, he was very well aware, and in his claim petition also he has stated that yes, I have had meeting with 3 times. I had meeting with the new promoter. Now, if that be the position, if promoter is somebody else, you know very well the position is with the new promoter. Now, how can you sue me and then okay, he may have some.
and you are not representing the interest of the present promoter also.
They have not in.
No, you are not concerned with what happens to the new promoter.
No.
It is
In
only
fact,
that
my
whether
lord-
you could be saddled with the liability as a promoter when your case is that you are no longer a promoter and all the liability had to be settled on someone else.
Someone else, and
So-
that person is not on record before the authorities. And then, my lord, even I owe 2 flats from the new promoter. That was
Did you appear in the before the tribunal? Yes.
whom, my lord?
Before the for the first litigation, did you appear?
Yes, I did.
There did you
I-
take up this ground that I'm
yes,
not liable
yes,
and I'm not a promoter?
yes.
Where is that?
We have said in our written statement also
Where?
for the proceeding, in the proceeding. My lord finds it page 19.
19.
I have stated in paragraph 1 that my husband has expired in the meantime, after taking over the project from Gargi, paragraph number 3, page 20. Has your lordship got it? So, after taking the Gargi Associate, Mr. Madhav Sharma, public notice advertisement dated 21/6/20 published in Astamia Protidin, informed the public in general that he had taken up Messrs. Gargi Associates and shall carry out the entire incomplete construction work by himself, and that he has changed the name of the apartment into Ganga Shanti apartment instead of previous name Naina, which was given by the previous builder, Messrs. Gargi Associates. After taking over the project from Messrs. Gargi Associates Private Limited, Mr. Sharma had had several meetings with the allottees who had booked their flats from the earlier builder, Gargi Associates. Interestingly, Mrs. and Mr. Anil Hajarika, the complainant here, along few others, were the only person who had made full payment and final payment at the booking stage itself. Therefore, the entire consideration amount of the respective.
Yes, sir. What do you say? What do you say to that
The
argument?
contention that she is no longer a promoter.
Hmm.
If that was decided, this issue was raised before the RERA, and it was decided in the impugn order itself.
Where?
Lordship, the order starts at page 38, and the issues are at
That particular issue that she is no longer the promoter?
yes, page 47.
Hmm.
Page 47, your lordship will find clause E, issues.
Hmm.
Whether Messrs. Gargi and Associates Private Limited is liable to implement the agreement for sale dated 19/4/2013. That is the agreement with us. After a deed of agreement dated 19/10/2019 was signed between Messrs. Gargi and Associates Private Limited
and Sri Madhav Sharma handing over the incomplete project Nayana apartment for completion and development. Now, the order part you'll also will find that in the same page. Order it starts issue number 1. It is revealed from the papers submitted related to the deed of agreement numbers such and such dated 19/10/2019 that the deed of agreement was executed between Messrs. Gargi and Associates Private Limited, first party, and Sri Madhav Sharma, second party, and that the agreement was signed by all directors of the board of directors of Messrs. Gargi and Associates Private Limited, that is Sri Pranjal Kumar Bharari, secondly Srimati Tobi Bharali, the petitioner herein, and thirdly Upasana Bharali, her daughter. It is also revealed from the letter dated 12/2/2021 from Srimati Sabi Bharali addressed to Mr. Madhav Sharma that Srimati Sabi Bharali signed the letter as director of Messrs. Gargi and Associates Private Limited, a company being a legal entity separate from and capable of
No.
surviving beyond the life of
What we are trying to understand is this, we will not go into the
Lordship.
merit of the appeal or merit of the order itself.
Huh.
We don't want to decide that. That goes before the appellate authority. What we are trying to understand here is whether when someone raises the issue that this liability should not be upon me, and he is not approaching as the promoter of that property, is he still liable to pay that particular amount?
Here the answer is given, in the implementing order, section 16 of the Act.
Hmm.
Section 15 of the Act. The
That
answer
it
is
could, that liability could not have been transferred.
transferred.
So that
Correct.
is a wrong position, that all that 15 and 16, it will all be held against her, whatever happens,
Right.
all those arguments will come in later on.
Yes, he cannot.
Thing is, the claim, her claim is I am not a promoter. Her claim is I am not a promoter. Therefore, the
cannot-
appeal is not being filed
He
as a promoter.
cannot cease to be a promoter, Your Lordship, as per the operation of this section 50. Lordship will kindly have a look at the language, section 50. So what is our obligation as a promoter? And section 15, Your Lordship, obligations of promoter in case of transfer of a real estate project to a third party. How a third party will be brought into a real estate project, that is clearly laid down here. The promoter shall not transfer or assign his majority rights and liabilities in respect of a real estate project to a third party without obtaining prior written consent from 2/3 allottees, except the promoter, and without the prior written approval of the authority. The two conditions are there: 2/3 of the allottees, and they have to take prior approval of the authority also. And the exception is provided that such transfer or assignment shall not affect the allotment or sale of the apartment, plot, or buildings, as the case may be, in the real estate project made by the erstwhile promoter. So the rights of the allottees are protected. Even in so her case, Your Lordship, she is only delaying what is her liability under the Act, under the law. And moreover, Your Lordship, she ought to have filed an appeal before the Honorable High Court under the statutory scheme. She has filed this writ jurisdiction. There are judgments of the Honorable Apex Court saying that when there is a statutory scheme, the High Court, if the appeal is before the High Court, then the High Court generally should not interfere in by exercising writ jurisdiction. And moreover, Your Lordship, she is on the point of locus. She has filed this writ petition individually. Although in the agreement part, it is Gargi Private Limited, Gargi Associates Private, it's a company. So even her locus standi is not there in the writ petition. And non-joinder, the non-joinder of necessary party, because I am the flat owner, Anil Chandra Hazarika. I have brought the flat along with my wife. She has not made a party to my wife is not a party before this proceeding. Although she was before the RERA and the RIA, here she has not made a party. So, Your Lordship, in my humble submission, this petition may be dismissed, and this will pave the way, because I have paid her long back. 2013, I have paid her 34 lakh. 2010, probably. Not a single penny I have received. During all this, they're not. Well, I'll place the judgment.
Hmm?
What the judgment? And
Yes, the liability could not have been transferred. Again, we are back to square one.
Well,
The transfer of liability, you becoming a non-promoter, that would only operate if the transfer was legal. It is not legal. You remain a promoter. Even that argument goes. Hmm. Otherwise, we do not find anything wrong with the order of the tribunal, of the appellate authority. The law says it will not be taken into. That time and again,
what is that?
you paid 34 lakhs.
34.
And why, how does it become 64 lakhs?
Along with the
Penalty.
interest. On the.
So what is the amount that now you are entitled to?
Lordship, now I have filed in my at the affidavit in opposition, Your Lordship, at page 101. Page 101, Your Lordship. Third paragraph.
Huh?
It is
Page 100 and
101. The third paragraph. The District Commissioner, Kamrup Metro, is hereby asked to submit the report of the certificate officer as regard the non-execution of the earlier certificate dated 27/1/2023. The District Commissioner is hereby also asked to ensure the realization of the amount of rupees 68 lakh
No, no.
75,000.
fresh certificate of relation of difference between 68 lakhs
Yes.
minus 58 lakhs.
Yes, yes, yes.
That is 10 lakhs.
And about 9 lakh 92,000.
Huh.
There was a mistake in the earlier calculation. So that when we had pointed it out before the RERA. and
You
we-
have paid 34 lakhs each. No.
No, together we had
And it went up to 68 lakhs
68
with the interest.
interest. Now.
compensation, my lord, compensation and
Interest,
penalty.
compensation, everything together came up with 68 lakhs.
Yes, yes. Now, in fact, 68 lakhs I will not get a good tax also.
Hmm?
Now, the prices are so high, 68 lakhs I will not get another good flat in that area. He was supposed to give me a
It's
flat
not-
measuring.
When you multiply the proceedings, my lord, if we see the ground reality, now I have to again sue the Madhav Sharma to get back the possession of this property. Then only I can.
There is a saying in English, to each his own. You create a tangle, you open the tangle. Why should others open the tangle for you? We are not finding much. Can only observe that you would be. The decision on this will not debar you from approaching appropriate authorities for appropriate relief. Or any other relief that you might claim for. Otherwise, you're not finding anything wrong in this order. Hmm? Another factor that is also there is that time and again you sought
That is
opportunities to deposit the money.
I'm not, my lord, on that issue because my instruction is that it was without her instruction. Anyway, I'm not taking this.
Yet.
In fact, my lord, after death of her husband, everything was like, and this person suffered a kidney failure. So that time, whatever came, she accepted.
Hmm?
Whatever came, whichever way she accepted that time. And thereafter, proceedings were initiated, recovery, everything has been
sold off in the proceedings of recovery proceedings also.
Mm.
So, and then she was in no position to.
If there are orders from the Direct Recovery Tribunal, then you cannot even give a bank guarantee.
No, no, it's not
Then
in a
that part
position.
is also gone.
Thank you.
No, nothing. We dispose it of.
And-
Third miss. P. Chakraborty Learner Council appearing for the petition also at Swinson Learner Council appearing for the respondent number 2. This writ petition had been initiated by the petitioner being aggrieved with the order dated 1st of November 2022 passed by the Assam Real Estate Appellate Tribunal at Guwahati in REAT oblique estate oblique appeal number 10 of 2022. Posted by the aforesaid order, comma, the tribunal had refused to entertain the appeal filed by the writ petitioner herein by dismissing the appeal in limine on the failure of the petitioner herein to deposit the statutory requirement of an amount of rupees 64,21,955 being the principal amount and interest calculated up to 22,82022 in terms of proviso to subsection 5 of section 43 of the RERA Act 2016. Full stop. Why not 30%?
30% is only for penalty part. If it is refund, then entire amount.
It's
As per
30%
section
of the
43.
penalty.
Yes, only the penalty for delay and.
Full stop. Really? Stop. The facts leading to the present writ petition is that the respondent number 2 along with his wife within bracket who has not been arrayed in this writ petition as a respondent, comma, bracket close, had approached the Real Estate Regulatory Authority Assam in case number Assam oblique RERA oblique 2017 oblique 47 against one Messrs. Gargi Associates Private Limited, comma, a company, and the writ petitioner herein, comma, describing her as a director of the said company, complaining that although the full amount for although the full amount for in respect of a sale agreement for a flat had been paid to the builder, comma, the said flat had not been handed over to the respondent number 2 and his wife, full stop. The Real Estate Regulatory Authority by order dated 2/6/2022 had held that had directed the company, that is Messrs. Gargi Associates and the writ petitioner herein, comma, as the director of the said company, to return the full advance amount of rupees 34 lakhs with interest at State Bank of India's marginal cost of lending rate plus 2% calculated from the date of receipt of the amount as prescribed under Rule 17 of the Assam RERA Rules 2017. Full stop. The amount along with the interest was directed to be paid within a period of 45 days from the date of the order. Full stop. Challenging the aforesaid order, comma, the writ petitioner herein filed an appeal before the Assam Real Estate Appellate Tribunal, comma, which came to be registered as REAT/Estate/Appeal number 10 of 2022, comma, wherein by the order dated 8th of September 2022, comma, the petitioner was directed to deposit an amount of rupees 64,21,955 in the form of demand draft drawn on a nationalized bank in favor of the tribunal within an outer limit of 3 weeks from the date of the order. Full stop. The matter having been listed again on 30th of September 2022, comma, the time period for deposit of the amount was extended for 30 days on the request made by the appellant therein oblique writ petitioner herein and by the order dated 1st of November 2022 on the failure of the writ petitioner to deposit the aforesaid amount, comma, the appeal was dismissed in limine along with imposition of costs of rupees 5,000 on the petitioner herein for backtracking the undertakings given to the tribunal with wastage of judicial time. Full stop. This order is under challenge in the present writ petition. Full stop. The registrar of the Real Estate Regulatory Authority has filed the affidavit in opposition, as well as the respondent number 2 has also filed the affidavit in opposition. Full stop. We have heard the learned counsel appearing for the contesting parties. Full stop. The provisions of the Real Estate Regulation and Development Act 2016 in section 43 has clearly mandated that where a promoter files an appeal with the appellate tribunal, the appeal shall not be entertained without the promoter first having deposited the total amount to be paid to the LOT, including interest and compensation imposed on him, if any. Full stop. In the present case, the petitioner has not been able to demonstrate any violation of the provisions of the Act. And it appears from the records that ample opportunities have been provided for to comply with the statutory requirement of payment of the statutory amount, comma, failure of which would naturally lead to rejection of the appeal. Stop. In view of the mandatory provisions of law, comma, this court does not find any cause to interfere with the order dated 1st of November 2022 passed by the Assam Real Estate Appellate Tribunal in REAT/Estate/Appeal number 10 of 2022. Full stop. The writ petition is accordingly dismissed. Full stop. However, the disposal of this writ petition will not preclude the petitioner from availing such remedies as may be available to her in law. Should we write that or no?
Let's say if you want observation that she is not in possession, that about the
Any other,
agreement transfer.
any other shall not preclude the petitioner from availing such other remedies available in law, comma, since it has been stated that she is no longer in possession of the property in issue
By virtue of the agreement dated
by virtue
1910,
of the agreement dated
1910-19,
1910-19 executed with No,
one
you do
Sri
not know.
Madhav Sharma.
by which the petitioner submits that all liabilities had been transferred. Full stop. We have this court has not commented upon the legality or otherwise of the transfer of liabilities asserted by the petitioners through the agreement. Full stop. We have observed that also. We are not commenting on the legality or anything of that agreement. She can pursue her. Yes.
Item 5.
Yes, sir.
May I please read it? My lord will kindly look at the last order, 22/10/2025. Last order, second page, last paragraph. Yes.
Hmm.
The land has been cleared now.
Demarcation written.
Measurement.
Yes, jungle has been cleared.
According to them, jungle has been cleared. Whether measurement also was done, petitioners called upon. Then report has been sent to the government advocate as per my inspect. So the government will file the affidavit.
When was that?
One report is already there.
But this is
That
22/9.
is regarding that.
That there is a jungle and it cannot be measured.
Thereafter, also I have to get the inspect.
Okay.
I have not
So
yet.
we record your submission that the jungle has been cleared, that the land has been measured.
Right.
And the report has been sent to the government advocate. Government advocate is seeking some time for instructions. By when? First week of, immediately on the reopening.
Yes. By this time, Lordship will.
7th of January would be fine.
Lots.
Heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard Mr. Sharma learned counsel appearing for the respondents. Full stop. It has been stated at the bar that pursuant to the order dated 22/10/2025, the jungle had been cleared. And the
Land has already
land
been
has
measured.
also been measured.
Right.
Full stop.
And the report has
The
been,
report has been sent to the and a report had also been prepared. Full stop. Mr. Sharma, Learned Counsel appearing for the respondent has paid for an accommodation to bring on record the report.
Lordship.
Full stop. List this matter again on the 7th of January to enable Mr. Sharma to have his instructions on the report
Lord.
stated to have been submitted after the land in issue had been measured. Yes.
Item 6,
Maksud.
Please, your lordship.
Also, we will find the, at page 19, an extra vehicle registration,
Page 19.
19. This is the registration of the vehicle on favor of my late husband,
Hmm.
Kamaleshwar Prasad Singh.
Hmm.
Thereafter, he expired on the date of death is 28/3/2023.
Ah.
Thereafter, lordship, an FIR was filed by the private respondent,
Hmm.
stating that she has given 8 lakhs amount of rupees 8 lakhs as loan for
Hmm.
purchase of that transport.
Hmm.
Thereafter, lordship, if your lordship comes to page 21,
Hmm.
Vahan Citizen Service lordship,
Page 20.
1,
Ah.
vehicle flagged as not to be transacted.
Okay.
Now, lordship, she has filed respond number 5 has filed a application before the DTO Buxa Assam, page 25.
Hmm.
He has stated that I beg to state that Srimati Kavita Devi, wife of so and so, so and so, so and so. I was a business partnership with late Kamaleshwar Prasad Singh. I had invested 8 lakhs at the time of purchase of the vehicle for business, bearing following details. Now, as per my knowledge, late Kamaleshwar Prasad Singh is involved
Which page are you reading?
page 25.
Ha.
This is the letter from the private respondent to
Ha.
DTO
DTO.
Buxa.
Then.
Now, last line, lordship, it is hereby period that till the dispute is resolved, the transfer of the ownership of the vehicle is not done without my consent. Which is lordship. Now, if your lordship comes to page 28, annexure 9, this is the notification issued by the Ministry of Transport and Highways, Government of India.
Which one?
Page 28,
Uh,
dated 3 April 2023. I'm relying on page 30, serial number 9. On demise, lordship got it. On demise, serial number 9, page 30. On demise of owner of the vehicle, if any, legal heirs file a complaint with registering authority not to transfer ownership of vehicle in dispute. She is not the private respondent, is not the legal heir, lordship. The petitioner is the legal heir. How can she file a complaint and vehicle was kept in the open sky? And so far my information goes, lordship, I have been instructed that one wheel is also, tire is also missing, lordship, from the vehicle.
We will not go into missing wheels, sir. Let us not be looking after missing wheels. Yes.
Lordship, this serial number 9 trucks in my case.
What does respondent number 5 have to say? Who appears for 5? Huh?
She is not the legal heir, lordship. She cannot file.
Yes.
My lord, if my learned colleague does not wish to file a reply to my affidavit in opposition, perhaps certain amendments are made in the affidavit in opposition may be deemed to have been admitted. My lord, before I begin with my affidavit, my lord, my learned senior has pointed to clause number 9 of that notification to press about that particular clause. My lord, may I draw my lord's kind attention to page number 12 of the writ petition. Therein, my lord, he has stressed on point number 7. Now he has resigned from his statement and stand on oath in a writ petition saying that it's a different ground altogether. My lord, at this stage, whether that may be permitted in the first place. His grounds was totally different. Secondly, my lord, he has not come with clean hands, man. That is my humble submission, because if my lord produces my affidavit, I have brought on record certain legal developments that had happened on the sidelines of it, which in the writ petition has not been reflected, my lord. And
The number-
by submission, those are material facts which should have been pleaded before this honorable court. If I may take my lord's
The
kind
copy which
attention
was
to-
served upon me, lordship, that affidavit of opposition, these are all, the numbers are different, lordship, page number, it starts from page 43. Then lordship 31, then 32, then 50,
All up and down.
all.
Stitches are up and down.
Yes, Lord.
Perhaps my lord, his copy, perhaps the page number in his.
Okay, at two, get it corrected.
Yes, my lord.
Get it corrected, at two, we'll take it up.
Yes.
If the page numbers are corrected, then we can take it up. And,
I have received instructions from
Ah.
both the TPOs.
Ah.
Because of the complaint made by the private respondent,
Ah.
they have marked the not to be transacted.
where is the provision? In law, where is the provision? Private respondent will have all sorts of claims. They have to go and get a,
The FIR which I have
Ah.
has given to.
the FIR is that I had given his father some money, his
Yes, I
friend some money, I went to ask the money
Yes.
and I was ill-treated.
My lord, may dispose of this matter.
I don't think that is the way in which
That is
that, yes. At two, after the papers are corrected. Yes, sir. At two, you give him the corrected papers. At two, Mati.
Item 7.
Yes, sir.
My lord. May it please your lordship, my lord. My lord, here, my lord, I am the auction purchaser of a plot of land. My lord, bank issued one, my lord, auction notice pursuant to that I participated, my lord. Now, my lord, the sale data is a page 23. They sold us, I paid the amount, they took it, my lord, 2014. In between, there was some litigation. Even the borough approached before the honorable division bench, my lord, honorable division dismissed their application. And even thereafter, they sought for liberty to approach them, my lord, DRT, they have not approached. They filed, my lord, one suit. That suit was also rejected, my lord. The
Very
plaint
recent
was,
judgment of the Supreme Court. What is that? Once the sale letter is executed, you
you have to-
cannot keep it back. It has to be given to the purchaser.
Yes, my lord.
Whatever be the rights of the debtor.
yes,
Then
But my problem is that your lordship, when
There
we
is a
went
stay.
there.
there is a stay somewhere.
No, no,
Ah,
there's
then-
no stay, your lord. I
Ah.
don't it. But my problem is that your lordship, when in the year of 2014,
Mm.
the property was a vacant property. But thereafter, when the litigation was started, then he has put some other person on the strength of some sale deed and some tenants was inducted.
Mm.
So the executive magistrate is hesitant to take the possession because we have to go by the system. So we have only one system to take the possession, that is section 14 of the surface. That is why we are hindered to take the.
You return him the entire money with how much?
my lord,
18% interest.
No, not the petty, because this is not the criteria of the bid.
and he's,
This is not the criteria of the bid.
no, no,
Because they have
You have
accepted the
kept
sale
his-
certificate.
You have kept his money from 2014.
yes,
Yes,
my
sir.
lord.
You
And
did
that
not
money,
give him the plot of the house in 2014.
Yes.
Was the tenant still there in 2014?
No, your lord. At that time, there was
You
nothing.
did not give it to him then.
There was nothing, your lord.
Then
So we have
Later on,
handed
you
over
allowed
the
some
possession
people
as
to-
well as the sale certificate also.
Huh?
Sale certificate was issued, your
Is the
lord.
Supreme Court judgment?
It is
Well,
Celery
yes,
LLP
yes,
Where is
Bafna
the
Motors.
Supreme Court
your lord.
judgment?
yes,
It is Celery LLP Bafna Motors.
Huh?
It is Celery LLP Bafna Motors.
Then,
Very common judgment.
then.
But my problem is that I could not able to execute now.
no, my lord, this 10 is wrong as per law, my lord, because kindly see, my lord, section 13, section 13 of securitization reconstruction financial asset. The bank has to be in possession first.
No, no.
My lord, no, before issuance of any auction later, my lord, bank takes possession over the land.
Mr. Das,
Yes,
situation is this. At that point of time, they should have given it to you.
yes,
They did not do it for whatever reasons. Now, some other people have entered. Some people, other
Yes.
people are in possession now,
yes.
admittedly. So what is the next step by which you can get what you deserve? Either we direct them to hand it over to you as is
That's
very,
better, my lord. Some time may be given, I don't mind, my lord. Let them do whatever as per law, and within that period, let them give me the
That
position.
sale- That sale deed is prior or?
No
after
sale deed,
the-
my lord.
No,
This is wrong submission.
Huh? You said some tenants are there.
Yes, tenants
Based
and
on
as well
some-
as one building has been constructed, your lord. One RCC building has been
You could
constructed.
not protect your own protected
No,
property
your
which was
lordship,
under
we
your
have already,
possession. Huh?
but this was done during the tenure of the litigations, your.
My lord,
No,
this
you could
is-
not protect your property at that point of time. It was in your possession.
So, your lordship, it is not in our possession.
How? Then how
Because
could you sell it?
by virtue of some stay orders, he has taken back the possession, your lord.
Where is that?
Yes, sir.
Where is all that?
Yes,
Can you
yes.
show us?
And my
It
lord-
is in the submission of the writ petition, your lord.
My lord, even in
You have
the,
not responded to the writ petition till.
no affidavit, he is taking the matter, my lord, last
No, I am
4,
not
5
taking,
occasions.
your
my lord.
lordship. I am getting the avenues that somehow I can hand over the
We
possession.
understand that and therefore.
We
let
are
us
in
entertain
continuous
you for
talk
some
with the
time.
executive magistrate there.
Huh?
We are in continuous talk with the executive magistrate, but
Huh.
My lord, in the land record, the name is there, my lord, that বেংকৰ লোন লোৱাত এই মাটি বন্ধকত ৰাখি নথি সংশোধন কৰা হয়. His land is in the name of the Central Bank of India. How he can make this submission, my lord? And section 13(4) is very clear, my lord. 13(4)(a), take possession. Bank has to take possession of the secured
Some time may be allowed
asset.
to bring with the affidavit, your lord.
Earlier occasion, same, there are
Yes, your lord. I have paid,
earlier,
but I have paid
third
because,
occasion.
your lordship, I was thinking that somehow I could get some avenues to hand over, but after getting
what he
entire
forgets
episodes, I
everything.
could not able to.
Mr. Das, if you
Huh?
keep objecting, except embarrassing him, nothing is going to happen. Ultimately, he has to file an affidavit. Ultimately, we have to take it on record.
Because of the case 20, my lord.
Hmm?
This amount I took on loan, my lord. What I paid for purchasing the
Your lordship, but
auction
this is
purchasing.
not the condition of the
Yeah,
sales.
no,
certificate.
your condition is all right.
It is under the
See,
cabinet,
my
it is there.
position also, my lord. 25 lakhs I took loan, my lord. And with some other amount, I paid 29 lakhs 50,000, my lord, 2014, to earn something from the land. Nothing, my lord, no income, my lord. So,
Yes. Heard Mr. BK Das, Learned Counsel, appearing for the petitioner. Mr. Das has submitted that the sale. Where is that sale certificate? The sale
it's
certificate
20, my lord.
27 9
regard to the
2014.
property in issue was issued on
27 9 2014.
2014.
Yes.
And now after 11 years of such sale being executed, comma, the petitioner is yet to get a hold or possession over
Possession.
his property. Full stop. The Mr. Sharma, Learned Counsel, appearing for the
Respondent number
respondent bank,
120.
has submitted that all due efforts are being made to clear the property from
To keep the possession,
to
to keep the possession of the property to the
to give the
petitioner.
possession of the property to the
Auction
petitioner,
purchase, yes.
since it appears that some
Litigation, sir.
litigation had taken place in the meantime, and there are some occupants on the aforesaid property,
Property.
and some construction has also
Also
been
been done.
created. This court notices that similar submissions had been made
27 8 2000.
and 27/8/25 and 3/11/2025
3/11.
on which dates this court had allowed the bank to file their stand by way of an affidavit before this court. Full stop.
For that,
Such
I'm sorry.
affidavit is yet awaited. Full stop. Mr. Sharma praised for being granted another opportunity to bring on record the stance and the latest development with regard to the
Handing over position.
handing over position to the
Of the-
petitioner. Full stop. List this matter again on 27th of January 2026, by which date Mr. Sharma shall ensure that an affidavit is filed, bringing on record the latest development in the case.
Lordship may kindly add one line, my lord.
Yes.
On failure to do so, my lord may be pleased to dispose of the matter. Otherwise, my lord, they will not.
What is your prayer?
My lord, to give possession, that's what.
Give the possession, your lord.
It may be, my lord,
Auto
dispose
refund
of
are
also.
So instead of an execution, we will go for a contempt. Hmm?
Lord, actually, my lord, for investment of, my lord, for raising one medical, this land was taken. But all these, my lord, plan failed, my lord. That's,
He wanted to serve the society. You are not allowing him.
I'm sorry. Anyway, obliged.
Item 13.
Yes. Item 13. You have the records with you, sir?
Yeah. Actually, that decision on the after the order of the court, one meeting was held with the executive engineer, and we have taken the decision. This is one regarding we have assessed what is the due and what can be done. Regarding that, that was discussed and that has been written. And on the basis of this minute, we have issued notice. And this has been done according to the order of this honorable court.
Where is the order of the court?
Yes. Last portion of the order. Of my affidavit, page 50,
Page 50.
affidavit of respondent number 34.
Hmm.
And it has been directed after submission of application, respondent 3 and 4 shall take necessary assistance of executive engineer, and thereafter he should be heard.
Sorry?
So,
Assistance from the executive engineer will be taken.
and thereafter
Whereafter, respondent number 3 and 4 shall take assistance of the executive engineer, and after hearing the petitioner, the respondent shall dispose of the same. Yes.
so after discussion with the executive engineer, we have assessed the whole matter. Actually, what is the due and what is entitled. So that meeting was held.
That is how assistance is taken.
Yes.
By giving a
And
hearing to
then-
the petitioner.
Yeah,
First of all, the decision will be taken, then he
No,
will be heard.
No.
Would you-
Thereafter, after we have given the hearing,
Ah,
that was internal assessment. That was internal assessment. That this is the
you are
due.
not required to take an internal assessment. You are required to take the assistance.
Yes.
Where is the question of an assessment, sir?
Yes.
Hearing was 29/9/2001.
Hmm.
Thereafter, this report dated 8/10/21 was. And along with that date, the check was also. Yes, accepted the same.
Your the submission that you are now making and the order that is before this court under challenge, they are stating two different things. Your submission is that assistance taken and then he was heard and a decision taken. Now come to page 56. complying with the Honorable High Court order.
Now, compared to the other side, direction and given an opportunity of being heard.
Mm.
The price was also called on 29/9/2021.
Mm.
1 PM in the office chamber of directors. And Deod welfare as somebody hearing the matter from his side about the decision taken on the
Just stop here for some time.
18/7.
Just stop here for a moment. A decision has been taken on 18/7, 18/9.
18/9.
Decision already taken. Then you are hearing him.
Lordship, the court is challenging is 8/10/21.
Because on 8/10/21, you have recorded that the decision of September 21, he was hard on that. The decision was taken prior to hearing him. Your order says so, madam. Your order says so. So therefore, what was that case? Maninder? No. What is it? Oh, Govardhan Das Bhanji. The order says that he got a hearing on the decision. Can you explain it later on?
And that it meant the thing.
Mhm.
Para-
Are you getting
Yes, sir.
what has happened? Why this court is asking you for the records? That the decision has already come, that we will deduct this much. Then he is heard. What do you have to say? That is not the manner in which a hearing is done. A hearing is done that this is what the executive engineer says. This we cannot pay you. What do you have to say on that? Then he will say, this is the reason why you should pay me. Then there will be an evaluation. Engineer says don't pay. He says pay. We find that he should not be paid. Is it not? We have decided with the engineer not to pay you. Now please tell us what you have to do. I'm already pre-decided. Can it be?
Then
Suppose I come and sit here and say that, okay, I have decided that this repetition is to be allowed. And then I come and say, okay, we are allowing it. What do you have to say? Can it be so? Cannot be.
But in
I have to
the
sit here, listen to you, then decide what to do.
then in the after hearing, when he appeared, he could not show why
It
how
goes.
he is entered.
Once your mind is framed, whatever he says or he does not say, it goes. The decision goes. You are predetermined. We cannot assume that you are biased. We also cannot assume that you are totally fair. What do we have to see? The circumstances. Whether it appears that he was given a fair hearing. If you decide first and then you hear him, law says post-decisional hearing is an eyewash. So hear him properly.
Then my
That
lord,
is all you are required to
Yes,
do. Hear
yes,
him
yes.
properly.
but in the order,
Huh.
Their criticism says that I was only to present to be the minus of the meeting which the decision they've already taken. In fact, they have heard me.
Yes.
There is no finding what I have submitted
Hmm.
because they were reluctant to hear me. I cannot still see one time. This is a small time.
Hmm.
Now, what is salvage? Those were desperate. And therefore, those were required to be placed. So by starting the value at the original cost of footwear.
that is that not be said.
Hmm.
One thing can
But there is a creativity.
After all, there is a finding that you were holding the key and you are saying everything is missing. So we would not like to go into that part. Yesterday, I think that was also discussed.
Whether the good and miss are also only the salvage.
Those you will all, once you get a proper hearing, you will raise all issues you want to raise.
I can praise. But your lordship.
I think these can be settled by the arbitrator
Huh?
and the arbitrator and arbitrator clause is there. So he should approach the arbitrator and there everything can be settled, my lord.
There is arbitration for arbitration. If there is any dispute in the work, now there is no
Yes,
dispute.
what is
No property of concern. The issue is-
Yes, I think you can come back after a short break and perhaps Madam can assist you
Yes, I can
Please-
just go through
Please, please paginate according to the file that we are holding. Your page number 52. In our record, it is page number 174. So that. Do it, you have got 1 hour maybe. If you take the page numbers correctly, we can be quicker. Thank you. Yes.
For 9 days
Ha,
hearing that,
ha,
just it's from the advocate general is going to
okay.
apply it.
When? 11 years down the line, when? I understand. But 2014 matter, we have to come to a conclusion also whether yes or no. We just can't keep it hanging. Huh? Yes. Although this matter was fixed today, Ms. N. Upadhyay, Learned Counsel appearing for the respondent has submitted that the Learned Advocate General would appear in the matter, and therefore some accommodation is sought for, which is not objected to by the Learned Counsel for the petitioner, submitting that adjudication in this matter would have long-drawn ramifications pan-India, full stop. Would have ramifications, full stop. Accordingly, list this matter again on some date, 26. In the first week of February 2026, by which time is expected that necessary pleadings would be completed and the matter would be taken up for, so that the matter can be taken up for disposal. Yes.
And you.
Item 13.
Yes. This 6/9/2021 you have given us. Yes. Here also you see already the decision by all the members have been taken and present payable amount has been calculated. Is it not?
Yes.
Then already resolutions have been taken that the Sports Authority of Assam will pay remaining calculated amount and also pay the security deposit amount, right?
Yes.
So all these decisions have been taken even before the petitioner had a chance to be.
That part.
So if that has prejudiced him, he never got his chance to place his case before you. And the
Again,
court
they
did
will
not want to,
consider.
the court did not want to go into the merits of his claim at
Right.
that point of time because we did not want to impose. You were given the opportunity. You failed to take the opportunity. Now what happens?
So thing may be again consider, but taken consideration, the result may come same
Why?
because what they have not done. For that, no payment will be made. So
It is
everything, I think,
From here, we do not find that it is because of any work not done that
that
he has
finding
been
has not-
refused.
that's not
You are
finding has
trying
not-
to recover the cost of scrap material from him which he did not return to you. So the question is not one of not completing the work. The question is one of whether you can adjust his bills against what he claims to be scrap and what you claim to be good material which was not returned to you after the construction of the work. Huh? Not all of them, not all of them. Whatever was found, because yesterday I remember Mr. Nayak making a submission
Act has,
that the keys and everything was with you.
act,
So whatever was
80
found,
something.
what was there, that is what has been said by the PW to be salvage. But not what was missing.
But there is more than that. Therefore, certain does becomes. The report there is no mention, something more than that. It will also be kindly take a painting. That
Where is that report?
not will kindly come to page 118 of the report.
Hmm.
The second last. May I read it?
Hmm.
As such, the members of the associate committee is the below the new. It is the threshold replacement of the four numbers of high mass lights of Indira Gandhi Athletic Stadium during the operation of mass equipment, electrical stuff in connection with the work, innovation such as such, etc. To improve the venue for holding the under 1970 World Cup 70, we are providing material for four numbers of high mass with operating board and IGCS is Guwahati during the FIFA under 17 World Cup event and calculated the total cost to be 28 and the present payable amount was also calculated plus 16 after deducting the already payments cost running fee. In this regard, the member also observed the payable security services. The Lordship, they have categorically stated third time that
They
it
have
is the-
also stated in the third paragraph from the top that no electrical old fitting and spares had been received by the electricians of the Sports Authority of Assam. So whatever was found was taken into account. Whatever was not found.
that not on this was already there.
Where? Where is that not found list?
That is at page 96. Your Lordship. What I want to say is that they have calculated the cost of the material of those which have replaced, which has been replaced. 95 Your Lordship, 95. The statement of calculation of depreciation value for the wood accessories spare parts of IPT in connection with the work, innovation, upgradation, construction, etc. at such and such to improve the development standard only under 17 megawatt providing meters of four number of hours with operating plan and available. Description of the materials unit given total work quantity of work executed. Now, how I compare this is quantity of the work. Actually, if we see the third pattern, that is the page.
Just a minute.
These are the goods which have been replaced. And these are the which are not in conditions.
Page 80.
The final, that is the third and the final. The Lordships. Number one, serial number one, unit 98 unit. What is that? Supply with and fixing of metal like lamp 2001. The Lakshmi compare it serial number 1 at page 95. Why the report
Yes, tell us.
the 98 months?
Hmm.
What is faced by us? These are not in working condition. Had it been in working condition, why the sports authority of Assam had tested? What I want to say is that this 98 bulbs were not in working. They were damaged and therefore they have to be replaced. These are the damage. And now if you're not come to page 118, that paragraph I'll read it once again. Your Lordship. As such, the members of the associate meeting and this is the total bill of the new fittings against the placed old replacement bills. It means although salvage goods were not found. And therefore, they have deducted the original price of the cost of working condition.
28 lakhs 41,498. They say they've already paid you 23 lakhs 52,000.
So the payment should have been like this. They paid me 60 lakhs, they
Hmm.
paid me 23 lakhs as the first starting,
Hmm.
which I said is 37. And there was an additional one
Hmm.
for 16 lakhs 40. That was also paid. That was in respect additional.
Okay. Kindly tell us which is your first running bill?
That is at page 71. Starts at page 71 and it's at page 7.
Page 71. Hmm.
Down below right side, 23,000.
Ah,
That's my first running bill. That's paid.
that is paid. Running bill paid. Now let us.
Now your lordship will come to second one. You're at page 70.
Page 75.
Starts at 75. That's
Ah,
11 lakhs 39,007.
ah.
Now
Not
your
paid.
lordship will come to the third run and the final run.
This is paid or not paid?
Not
Page 75. Second running bill. Not paid. Okay.
now page 80, third running bill.
Page 82. Third bill. Not paid. Is it?
Not-
Ah.
It starts at it ends at page 83.
Hmm.
5 lakh 2,170.
Hmm.
This bill has also not been.
So 2 and 3 not paid. Okay.
And the total value of 2 and 3 comes to 16 lakhs 91,240.
16 lakhs.
91,240.
Huh.
This is the only remaining unpaid.
Okay.
And they have paid 16 lakhs 40,000 for an additional work, which is not the subject. matter.
Now, have they paid you that 4 lakhs something?
Yes, I have taken it under.
So 4 lakhs and what was paid?
4 lakhs 88,802.
88,802 out of the 16 lakhs paid.
Yes. sir.
Out
In
of
1
this
lakh 75, that's a security.
That is not in contention anywhere. That
Yes.
they are not trying to retain and you are not claiming not
Yes.
paid.
So
Okay.
that amount has been paid out
Ah.
of this. So what remains to be paid is 12 lakh 4,000.
Yes, and that order of this food, where is there? Where is that?
That pay
107.
it starts at 108, basically the operative portion is at 110. But
110.
and 109 is option. But for one reference, that they have only paid the first running bill, that's the second tariff is submitted by Mr. Successor and it comes to the works completed as per the certificate of electrical engineer PWD amount 40 lakhs 40,944 said amount, the respondent she has released an amount of 58,000. So remaining amount is 16 lakhs, the figure I have just not given you. 16 lakhs 91,000.
Hmm.
Out of that, they have released told us 88,802, and they have deducted 12,2,446 only because of the fact that they have not found the replacement for which the executive authority has already calculated itself.
You are required to take into account the salvage report, page 110. At page 111, you are required to take into account the completion certificate along with the salvage report and the value assessed therein. Can you show me from your order that these were taken into account?
But I made this, that was not even considered, and if
Let him try to trace out.
there is no finding that that was rejected by.
Hmm?
It stands as if that was there. And PWD being the executive authority, they are bound by the decisions that affect.
So proceed. I draw your 176 page. 176.
Yes.
Yes. First running bill. Last post. He's going through it.
Hmm.
This is first running bill is the additional work. First running bill, what happened? That was not supplied at all. I am going through it.
I'm not understanding.
Hmm.
You are saying that the first array amounting to rupees 14,60,810 was not supplied.
Was not supplied.
So you made a wrong payment of 14 lakhs.
So that has been deducted from the.
Where? Show us from your this thing that we have deducted that. Where is that calculation, sir? In your order,
Yes.
where is that calculation? 23, your total bill was 28 lakhs. 41,498 and You are reducing this code to become an accountant. 1460,810. Heh. Still does not match. From 28, if you minus 14 lakhs, he still deserves 14 lakhs.
The lot of fact, let it help. There is a. That is.
I'm trying to ignore you because we don't like interruptions. Ah.
Actually, what happened, there was two works. First main work, for which paragraph 3, it has been stated
Hmm.
that this amount 23 lakh 52,600 something that has been paid. There is no dispute. That is the main work. Then additional works come. In additional work, these last two bills, second running bill and first running bill. But they have stated that there is 3 bills. Third bill they has not submitted till now. That has been stated. We have stated last line of this bill. Last line of this bill. So everything there, if we go through that manner, everything chaos. So it can be settled in the arbitration, I think. So let it send to arbitration. Because they will say something, I will say something. So everything that will be proved by the before the arbitration. Otherwise, again, if it is sent there, again one decision will be given, and again they will come here. So long run pending is it. And when this is a fact, dispute of fact, because we have stated the work has not been done as per our norms. So we have stopped the payment or deducted. So this, and whatever they have not done, they cannot do it now. So whether they have done or not, that can be settled in the before the arbitration. They should have gone there.
Hmm.
Yes, there is wrong of that authority without they have taken decision before hearing him. That wrong is there. That wrong is there. I also the decision has been taken before. But in spite of, even they now given the chance, same thing will happen. And they will come, I know. They will come again. Because whatever work they have not done, that cannot be paid. So this
Which is the work not done? Where is your standard? They
As
did
per-
not do
as
the
per-
work.
as per this order, this some matters has not been supplied. Some states has not been
He is not disputing that 14 lakhs bill. That was never an issue before the court. That was never an issue of his claim.
Yes.
You have drugged in a bill which was not within the purview of all this. You are trying to raise a dispute, saying that he has not claimed 42,000 that we had deducted. He is letting it go. We are on the first running bill, second running bill, third running bill. That is what this court is to decide. Why are you trying to complicate matters? Yes.
Court.
Hmm.
Last, the full work was excess done tax 41,490.
Where do you find that? Page 118. Yes.
As such, the papers of the state of the meeting have assessed the total value of the take the place full case materials of 4 number 5 months nights of Nagati the operation of 4 months required technical staff in connection with the work, location, upgradation, construction of IGAS the value the standard for holding under 70 World Cup 2007. Preparing and providing materials of the 4 numbers of 5 months the operating panel code at IGS C party the FIFF 170 and calculating the total cost be rupees 20 lakh thousand 20 lakh 28 lakhs 41,498. And the present payable amount was also calculated to be calculated as 6,88,02,802 after deducting the already paid amount. First running.
First running bill is 14 lakhs.
No, Your Honor. No,
Good.
Your Lordship,
What is the
it's
first running bill?
23 lakhs.
23 lakhs was already paid to 20.
Yes, sir.
First running bill is at page 71. 23 lakhs 52,696.
Yes.
And you state here that you have paid him.
3 lakhs.
Huh.
That's
Very good. Now the second bill was of
that second bill was of 11 lakhs 39,000.
yes.
Yes, Your Lordship.
And the third bill was of 5 lakhs. So 11 lakhs plus 5 lakhs is 16 lakhs odd.
Yes. Amount total.
This 16 lakhs odd, you have brought down to 5 lakhs by making it total of 23, 28. 23 paid
Yes.
and 28 you are saying that we are required to pay in total. So now his bill of 16 lakhs odd you have brought down to 4 lakhs approximately. On what basis? That is what we are asking you.
Your Lordship. That has been done. The joint verification of the electrical part of the PWC and the source of the facade.
Where he was not even there and you are deducting
Yes.
his bills.
Yes.
Is it permitted in law, madam?
Yes, Your Lordship. After that, he was given a letter.
Where is that?
That he was given the letter dated 8 September 2021.
True. This is
Present before that on 29/9.
this is after you took the decision to bring the bills down to 28 lakhs.
After
Yes.
where the part
Was that what the court required you to do? Was that what the court wanted you to do by the order?
Sure.
the last order of the court. The last paragraph, 110, 110,
Hmm?
110.
Hmm.
Here, and giving out the last paragraph, this matter is pending since law. Though the learned council has argued with respect continuity of this institution, however, without bringing the merit of the same issue, I am disposing of this petition with the direction. File the petition afresh before the respondent number 3 and 4 and 11, seeking his claim to the date this petition. Whereas the respondent number 3 and 4 shall take necessary assistance of the
Hmm.
PWD coordinated petition and thereafter letting the petitioner, the respondents, more specifically, respondent number 3 and 4 of the same. After taking the assistance of the PWD, then only he has.
You are going for something unreasonable. You are taking all the decisions within a closed chamber, then you are asking him what tell us about the decision. Is that natural justice? Or does he have to participate in the decision-making process? You have given him an opportunity to say what he has to say on the decision, not before taking the decision. Are you understanding now? Arguments complete? I can dictate?
Yes.
Heard,
One
Mr.
thing
Hmm.
in the order, the total of the old was not nothing, it was lost.
Heard Mr. R. Sinha, learned counsel appearing for the petitioner, also heard Mr. So-and-so, learned counsel appearing for, you are appearing for respondent number?
Yeah.
Respondent number 3 and 4. Who appears for PWD? Mr. P. Nayak for the PWD. What about 1? Department of Sports and Youth? Mr. Chetia. The present petition is the second round of litigation initiated by the petitioner. The initial writ petition being WPC 219 of 2020 had been disposed of by the order dated 11/8/2021. Full stop. The facts leading to the institution of the earlier writ petition has been recorded in the order itself, and the same are reproduced herein below for a easy reference. From page 108, you take from where I have marked as A to B. Okay. This court had disposed of the said writ petition by remanding the matter to by directing the petitioner to file a representation afresh before the respondent number 3, 4, and 11, seeking his claims to the dues made in the writ petition, whereafter the respondent number 3 and 4 were required to take necessary assistance of Executive Engineer PWD Guwahati Electrical Division, and thereafter, hearing the petitioner, the respondents were required to dispose of the representation within a period of 60 days from the date of the receipt of the said representation. Full stop. It was further provided in the order that in addition to the assistance of the Executive Engineer, PWD Guwahati Electrical Division, the completion certificate of the Executive Engineer along with the salvage report and value assessed therein should also be taken into consideration. Full stop. The petitioner had thereafter filed the representation on 17/8/2021. And by a communication dated 28th of September 2021, the petitioner was invited to attend a hearing on the 29th of September 2021 in connection with his prayer for release of dues amounting to 16,91,248 against the work in issue. Full stop. The petitioner attended the office on 29/9/2021, and by an order dated 8/10/2021, the claim of the petitioner was rejected by the respondent authorities, holding him entitled to be paid a total admissible bill value of 4,88,802 rupees along with the security deposit of 1,17,635 rupees. Full stop. the petitioner accepted the payment under protest and has approached this court now with a grievance that the order dated 8/10/2021 deserves interference of this court. Stop. Mr. R. Sinha, next pair. Mr. R. Sinha, Learned's counsel appearing for the petitioner has submitted that something was deducted from your security deposit also.
Just check this. I have completed the work.
No, here you have, in the prayer clause, you have asked for another 84,000, which was security deposit.
That's not with the 12 minutes.
That 84,000, you have got it.
So that I have not, but that is included the bid. Even that can be considered. That will be.
Yes, has submitted that. The deduction, no, and the calculation of the made by the respondents, whereby they arrived at a total cost of rupees 28,41,498 relatable to the work executed is and has been done so without giving the petitioner the opportunity to raise objections to the same, full stop. He has further submitted that records would reveal that the PWD had assessed the value of the had calculated the value of the old accessories, spare parts of the light fitting, etc., comma, which is available at page 95 of the writ petition, to show that the calculation of scrap value was approximately 5,460. Full stop. He has further referred to the said calculation to show that there were no other scrap value of any of the old fittings. And therefore, he submits that the calculation arrived at by the respondent authorities are without any basis, and that the petitioner therefore is required to be paid the full amount of the bill, since the work completion certificate was also issued to him with regard to the work. Full stop. Next para, the learned counsel appearing for the respondents has referred to the order dated 8/10/2021 to submit that in compliance with the order of this court, comma, the petitioner was afforded an opportunity of being heard. And after hearing the matter from his side, comma, the decision to pay the amount of rupees 4 lakhs and odd had been arrived at by the respondents, full stop. It is submitted by the counsel for the respondents that when the petitioner had the opportunity of raising grievances against the decision being arrived at by the respondents, comma, this writ petition does not require to be entertained in its present form, full stop. The learned counsel for the respondent has also referred to the arbitration clause, comma, submitting that since there is a provision for arbitration, comma, the present writ petition does not require to be entertained, full stop. Any other submission? Anything else to be recorded?
No.
This will
Only
do.
that-
Mr. Sinha, anything else to be recorded? No. Yes, this court has gone through the materials on record and has also considered the submissions made by the counsels for the contesting parties, full stop. It is a admitted position that the executive engineer, comma, PWD had issued a, where is the completion certificate? Has issued a completion certificate, page 88, had issued a completion certificate in favor of the petitioner, and it is also a admitted position that the executive engineer PWD had made an assessment of the, where is that assessment again? That salvage part. And also made an assessment of the salvage part of the salvage. An assessment of the value of the old accessories, comma, in relation to the work executed by the petitioner, full stop. It was in that view of the matter that this court had directed on the earlier occasion that while taking a decision on the claim of the petitioner, comma, the respondent authorities would be required to take the necessary assistance of the executive engineer PWD and also to take into consideration the completion certificate issued by the executive engineer along with the salvage report and the value assessed therein, full stop. To the understanding of this court, the petitioner was required to be given a hearing by the respondent authorities, comma, which would be with the assistance of the executive engineer PWD before a decision was arrived at regarding the amount to which the petitioner would be entitled to, full stop. Next paragraph. A perusal of the impugned order dated 8/10/2021 reveals two factors. One, now firstly, that the members of the meeting had assessed the total value of the new fittings against the traced old replaced materials and calculated the total cost to be rupees 28,41,498 and the present payable amount to be calculated at, now was calculated as 4,88,802. The fact remains that the petitioner was not made a part of the said meeting, and even if the assistance of the executive engineer, PWD had been taken at the while coming to the aforesaid decision, it is obvious that the petitioner could not participate in the deliberations of the meeting, and therefore, in the opinion of this court, the petitioner has been denied an effective opportunity of hearing before the respondents came to a decision as regards the entitlement of the petitioner, full stop. The order dated 8/10/2021 does not refer to the work completion certificate and the salvage report issued by the executive engineer, comma, which report were required to be taken into consideration by the respondent number 3 while coming to a decision, full stop. The order dated 8/10/2021 also reflects that the petitioner was called for a hearing on the matter from his side about the decision taken in the meeting held on 18/9/2021. এইটো আপুনি ইনভাৰ্টেড কমাছত দিব হা, for a hearing য'ত লিখিছে যে তাৰপৰা সেইটো ইনভাৰ্টেড কমা ষ্টাৰ্ট কৰিব 2021 এণ্ড কৰিব, ফুল ষ্টপ. This comma in the view of this court displays that the petitioner was at best afforded a post-decisional hearing, comma, which does not suffice the requirements of an effective hearing in the circumstances of the present case, full stop. Next paragraph. In view of the conclusions arrived at herein above, comma, this court sets aside the order dated 18/10/2021. Full stop. The respondent number 3, comma, 4 and 11, they are the same respondents here, are now required to take a fresh decision on the representation filed by the petitioner regarding his claim, comma, which decision shall be arrived at only after giving the petitioner a due opportunity of participating in the deliberations, comma, which would be done with the assistance of the executive engineer, comma, PWD electrical what? PWD Guwahati Electrical Division. Full stop. As required in the earlier order of this court, the effect of the work completion certificate and the salvage report shall also be taken into account, full stop. The claims made by the petitioner in his different bills and the calculation arrived at by the respondent number 3 with regard to the entitlement of the petitioner shall be done in a manner which would reflect the mode and manner in which the claims and the counterclaims are considered, full stop. This court notices that the work had been executed in the year in the year 2018 itself, and already there was an earlier round of litigation, full stop. In such view of the matter, the respondents are directed to complete the entire process of consideration of the claim of the petitioner within a period of 60 days from the date of receipt of a certified copy of this order, full stop. In case the petitioner is found entitled to any amount, comma, the same shall be paid to him within a period of 60 days thereafter. Writ petition disposed of, no costs. You take a decision after
Yes,
taking
sure.
everything into account, give him a fair hearing.
Department notice something wrong.
You may have all the
No, I shall guide them.
authority not to pay him, but
No,
then
I
he
shall
has to be
guide
heard.
them how to
He
pay.
has to be heard. He has to be effectively heard. Yes. Huh. Huh? That we have already said that all the. Hmm. That
Because
will
the-
complicate issues.
I'm saying,
When they come to a decision, they will take into consideration the work completion certificate and the salvage report is what we have said. The moment we say that any amount payable as per the work completion certificate, since the work completion certificate is there, pay me will be the issue. We do not want to go into that part of it.
But
Item 6.
Yes. Hmm. Sorry, who doesn't have an objection from transfer of the vehicle? Huh?
Don't work.
Okay, understood, yes. We'll keep that in mind, yes. Yes, sir.
Hello.
Ha,
My lord, before the lunch break, I had pointed my lord's attention to the fact that he had argued on a different matter. And in fact, in the writ petition, they had pressed on a different ground with regards to the guidelines that he had reflected upon. His contention was that on the demise of the owner of the vehicle, if there are any disputes within the family, then it cannot be transferred. But in the writ petition, in the pleadings, my lord, he had taken the ground that if there are any pending criminal cases, then it may not be transferred. That was his ground, the pleading. Now he has resiled on that ground and he's taken a completely different ground. Now, without being prejudiced by that, my lord, if my lord comes to my affidavit in opposition, my lord, they have not brought out certain fundamental facts which should materially affect this dispute. My lord, that's why I see that perhaps the clean hands doctrine has been violated here.
hmm,
If my lord may kindly come to page number 44 of my petition, my affidavit.
hmm.
This is, my lord, the original is in the previous page. This is the affidavit. This is a check which has been signed by the deceased husband of the petitioner, where it has been specifically admitted that 8 lakhs amount had to be paid to me. And my lord, it was in that pursuance that I had presented the check on the assurance of the husband, and it was dishonored, my lord. The dishonor memo is at page 46. Thereafter, my lord, I had no knowledge of the fact that the petitioner's husband had passed away. It was only when the wife and her brother-in-law had come from Bihar, they are original residents of Bihar, they had come to Guwahati, and then I met them and I came to know that the deceased, the husband had passed away.
Hmm.
Therefore, I had intimated the matter to them about
In
that.
the, just in between, may I just,
Of course.
you got the check bouncing information on 26/4/2023.
2-3, man.
What happened thereafter?
Well, thereafter, I had contacted them, I had informed them about
You
this
dropped the
issue.
issue. You did
Yes.
not follow the due process of law.
My lord.
You did not follow the due process of law.
My lord, because I wanted to ensure that if I wanted to inform them that this is
Yes,
what the
thereafter?
issue was. And then they
Thereafter?
assured me that, of course, there will be sufficient balance available. You please present it once again. I had presented it once again, my lord. It again got disowned. Thereafter, my lord, there was a certain criminal proceeding that had arisen thereafter. When I had interacted with the brother-in-law, there was some assault that had gone on and I had filed a police complaint. And thereafter, whatever he has presented, that the vehicle was blocked by the DTO. Thereafter, my lord, in pursuance of that, my lord, I had taken the due legal process. I had served them a legal notice, my lord. The legal notice is at page 63. That they have concealed, my lord. I have served them a legal notice. They have replied to that legal notice, my lord, in page 66, which shows that they were very much aware about the due, my lord. And thereafter, my lord, I have instituted a money suit, my lord, which is currently pending, my lord. But, my lord, it is quite regrettable that they have been avoiding service, my lord. So we have been directed to take fresh steps, my lord. Now that is where the situation is, my lord. And now I am apprehensive that because it is only the vehicle against whom the loan was advanced by me. Therefore, they are trying to get it in their name, and then they are most likely to alienate it. And therefore, I would not have any
Money suit.
collateral. Yes, of course, my lord. I am going to pursue my remedies, but my lord, they have to appear. That is where my limitations are.
Why don't you appear, sir?
My lord, now it is to their knowledge that it has been filed. I have brought it on record before the honorable court. It has not been received, my lord. My lord, then my lords may kindly direct them to appear on the next date.
Money, how can
My lords, the moment I had filed the affidavit in opposition, it had come to their knowledge, my lord. Now, if they keep evading that legal process, I'll have no means to enforce my claim.
So the page number
Inform the court, they will proceed ex parte.
My lords, if my lords makes an observation here that the next date is fixed on.
We'll record your submissions. We are not making any observations. We'll record your submissions. But you have not been able to point out any impediment in the transfer of the vehicle to
Yes,
the
my lord.
litigators. There is
I'll have to, my lord.
there is no impediment on that.
My lord.
If you can get some order from some court,
My lord,
then it's a different.
my only
Because
request,
when you
my
filed
lord,
the affidavit in opposition,
my lord.
you knew that there is no impediment. Is it not? So there is something called a temporary something, no?
Well, it's order 38.
See, you are being advised.
I'm aware of that, my lord.
Yes,
I'll address my client. My lord, my only request, my lord, the next date is on 10 to 2026, my lord, before the learned
We'll
senior,
record it.
yes, civil just senior division.
We'll record your submissions.
My lord.
There is no.
What is the direction for them to appear, my lord? Because it would keep repeating, my lord.
Yes. Heard Mr. Aadhar Learned Counsel appearing for the petitioners. Also heard Miss.
For one.
Yes. You have not applied for that. You have not informed them about the debt. Says here that you have not given any information about the death of the owner. Here you have given us, we are not going to transfer it. Huh? Yes, I heard Mr. So-and-so. This present writ petition has been instituted. Aggrieved by. Which does not have any receipt from them. Yes. Has been filed being aggrieved by the action of the respondent number three, whereby the vehicle bearing registration number AS28 AG0744 has been flagged as not to be transacted due to reasons recorded in the not to be transacted by referring to a police case under section 154 CRPC, etc. And a complaint by the respondent number 5. Full stop. The case of the petitioner is that her husband was the owner of the aforesaid vehicle bearing registration number AS28AC 0744, and on his demise, she had applied to the concerned RTO, to the concerned DTO, District Transport Office, for registering the transfer of ownership from the demised husband to the petitioner herein. Full stop. However, on inquiries being made when the transfer was not being allowed, the petitioner came to know that due to a complaint lodged by the respondent number 5 herein, the DTO, the concerned authority had flagged the vehicle as not to be transacted. Full stop. Mr. Ardhol and counsel appearing for the petitioner has submitted that there are certain there are only certain circumstances under which a vehicle can be flagged as not to be transacted, and the said conditions are reflected in the communication dated 3rd of April 2023 issued by the Ministry of Road Transport and Highways. Full stop. By drawing the attention of this court to serial number 9 of the categories for flagging of vehicles as not to be transacted on Vahan, the learned counsel submits that it is only in cases where the legal heirs file a complaint on the demise of the owner of the vehicle, that a vehicle can be flagged as not to be transacted. Full stop. The learned counsel has submitted that there is no order from any appropriate forum of law restraining transfer of the vehicle from the name of the deceased owner to the legal heirs. Full stop. In fact, in any case, a vehicle cannot stand in the name of a deceased person when his legal heirs apply for transfer of ownership. He accordingly prays that the respondents be directed to remove the not to be transacted flag against the said vehicle and further to process the transfer of ownership of the said vehicle to the legal heirs of the deceased owner, in accordance with law. Full stop. Mr. So-and-so learned counsel appearing for the respondent number 5 has submitted that the writ petition does not deserve any consideration from this court, since the petitioner has been taking varying stance and the bona fide behind the writ petition is not cannot be presupposed. Full stop. The learned counsel has submitted that while in the writ petition a stand has been taken that unless a vehicle is case property or under investigation and formal request made by the IO in writing to keep the file in safe custody or not to make any transaction has been relied upon by the petitioner, while addressing the court, the another ground has been taken that the same cannot be done in case the legal heirs do not make a complaint. Full stop. The learned counsel has also drawn attention of this court to the affidavit in opposition, to which he says no reply affidavit has been filed, that the petitioner is aware that a check issued by her deceased husband had remained dishonored and that the respondent number 5 was entitled to recover the same from the estate of the deceased, comma, which would also include the vehicle in question. Full stop. Yes, any, what other submission?
They have also replied to
Ah,
the,
the learned counsel for the respondent number 5 has submitted that legal notices had been served upon the petitioner, comma, to which they had also replied, comma, which has not been referred to in the writ petition. And therefore, he submits that there is suppression of material facts, comma, meriting dismissal of the writ petition. Full stop. Yes. One more submission you had. What was that?
Manishut has been.
The learned counsel for the respondent number 5 also submits that the petitioners are well aware that a money suit has been instituted by the respondent number 5, and yet the petitioners have refrained from participating in the said money suit, and even notices have been not, and the respondent number 5 has not been able to serve notices issued by the court on the
Manishut number 90 of
Mon-
2024.
money suit number so and so, and
Pending before the learned civil justice senior division number 2.
also, and notices have not been yet served upon the petitioners in who are arrayed as defendants therein. Full stop. He therefore submits that this writ petition is not filed bona fide and does not deserve to be entertained by this court.
Just one line. The next date is 6 on 10 to 2020.
He further submits that the next date for the money suit is fixed on
10 to 2026.
10 of February 2026. Yes. Miss MD Bora Learned Counsel appearing for the Transport Department has submitted that submitted on the basis of instruction that it is a fact that that upon submission of an application on 29/2/2024 by the respondent number 5, along with an FIR, along with a copy of an FIR lodged before the Paltan Bazar police station, comma, the respondent number 3 had flagged the said vehicle as not to be transacted to avoid any irregularity in respect of the ownership transfer. Full stop. Ms. Bora has submitted that the department does not have any information about the deceased owner taking any financial help from the respondent number 5 at the time of purchasing the vehicle, and in fact, from the records, it is reflected that the vehicle was more hypothecated to the Indus Bank without any reference to the name of the respondent number 5 herein. Yes.
The transfer of the vehicle, Rule 56, they have some documents.
The
Same here.
the learned counsel appearing for the state respondents also submit that unless the petitioner fulfills the mandates as required under Rule 56 of the
Same here,
1989, comma, the question of
transfer of owners.
consideration of any application for transfer of ownership of the vehicle cannot and does not arise. Full stop. This court has heard the learned, this court has considered the submissions made by the learned counsel appearing for the contesting parties, and also gone through the records of the case. Full stop. The learned counsels appearing for the respondent authorities or the respondent number 5 have not been able to bring any provision of law to the notice of this court that a vehicle can be flagged as not to be transacted in the absence of fulfilling any of the conditions laid down in the circular dated 3rd of April 2023 issued by the Ministry of Road Transport and Highways, comma, Government of India, or in the absence of any restraint order being issued by an appropriate forum of law. Full stop. In the absence of any such restraint being there in any such restraint in law being present, comma, this court is of the considered opinion that the act of the respondents in flagging the vehicle number AS 28 AC 0744 as a vehicle not to be transacted was not done in accordance with law, and therefore the same requires for the interference of this code, full stop. The said is accordingly interfered with, and the respondents are directed to remove the said flag in connection with the vehicle in question, full stop. It is made clear that this court has not decided the title or entitlement of the petitioner to claim transfer of ownership, without filing an appropriate application as required under law to the concerned authorities, full stop. It is provided that in case any such application is filed by the petitioner, the respondents shall consider the same in accordance with law, full stop. It is also provided that this court has not dealt with the rights of the respondent number 5 in any manner with regard to the claims made in the money suit. And the same shall proceed in accordance with law without any reference to the present adjudication.
Petitioner shall go
Huh? Since the pendency of the money suit has been brought to the notice of the petitioner during this litigation, the petitioner may take appropriate steps as advised. Yes.
may appear on the next date.
See, it is to their advice. Go for an ex parte order, huh?
But sir,
हाँ.
fee vehicle sir ऐसा था जो काम petro 16 आता था
No, he's only concerned with the
Uh,
Baksa part, not with the Kamrup part. He wants to let them go.
of that
The instructions placed by Miss MD Bora is returned to
specifically but
both of them. The instructions placed on record by Miss MD Bora are kept on record and marked as annexure as X and Y respectively. With petition disposed of, no order as to costs.
So obliged, my lord.
Item 14 and 15.
You should hearing it as
Four of this is same. Item 15, they have submitted.
she was required to have an additional affidavit.
That I have
No.
filed.
he has to file here file.
I have filed. It is on record.
Which matter you want us to take up?
14.
14.
Adultery construction.
15 we have raised the
Option of.
question of mentality on the ground of jurisdiction
Mm.
because cause of action doesn't arise because although it's an NF railway matter, but the Tribune order is by Jalpai Katihar Railway in respect of West Bengal, and secondly there is an arbitration clause and where it is specifically mentioned that any dispute is subject matter of arbitration.
Okay. What the purpose of manufacture of kind of sleeper that we use in elevator
Hmm.
or.
Between the two tracks, there is a sleeper, yes.
91, 89,
Hmm.
I have awarded a contract and we have entered into an agreement. At that time, what I have, for the purpose of manufacturing country, if we choose to provide clear land,
Hmm.
is nearer to find out that track and all.
Huh.
So that for the purpose of loading and unloading, initially first free of cost, but subsequently 1985 was placed, and on the basis of that, they started charging for the land license.
Hmm.
The issue, in fact, I will refer to. Then issue was that by this one coordinate measure.
Hmm.
So lot of is 38.
Hmm.
The agreement of license date of 1989 between President of the Ethics of Commercial in respect of a temporary occupation of land belonging to government situated in Jaggi Road, lot number 12.
Okay.
So that was noted time to time. They had give us
Mm.
one quarter also. One quarter, please, 27, I will find it.
Mm.
These are the work order. Next. Time to time, work order. She expected work effort.
This is annexure 1A, no? Huh.
Annexure 1. Part of annexure.
Mm.
Annexure 2, page 69.
Hmm.
Very important. 4, 10, 5.
Mm.
Policy on type of railway land for block.
Mm.
Third round of meeting. I will come. Third round. I don't need over. And time the page 52.
Mm. Yes.
Close number 5.
Huh?
Clause number 5, fixing of land value.
Page 52. Some mistake where our page is 51. 51.
51.
Ah.
My,
Okay.
on my part,
No issues. Huh? Bolo.
Clause number 5, fixing of land value. A market value would, however, be required to be taken to serve as a case value for working out rental fee payable. This shall be fixed on the basis of some typographical mistake and value of the surrounding area as on 1/1/1985. This is important. Since it was not done, your lordship, and they have raised demand that your lordship will find at page 70.
Hmm. Of the land value of the surrounding
Mile.
area. Oh.
So they raised demand without considering my lord that aspect of the circular. That demand was raised, page 59, 70. Amount is 59,03,214.
Hmm.
We approach this honorable court. First, we have raised my lord to the authority. It is not in income, my lord, as per the circular.
Hmm.
So we approach this honorable court, and this honorable court, page 77, my lord. And 78 is the operate, my lord, in view of the bottom, my lord may skip over. In view of the aforesaid situation, your lordship has got. In view of the aforesaid situation, without keeping the writ petition pending, and as agreed by London Council for the parties, this writ petition stands disposed of at the motion stage with the following direction. Respondent number 6, so NF Railway, Lamding, shall take up the representation filed by the respondent on so in the form of appeal with regard to payment of arrear license fee of the petition and consider a liability in terms of clarification and direction issued by Chief General Manager, White Communication, dated 6/4/2010. Such decisions shall be taken by the authority as early as possible, not later than so. Thereafter, my lord.
Stands finally closed.
This is a demand made by so. By dated shall not be given effect to the authority shall dispose of the matter by passing the speaking order. So, my lord, till the decision was required to be taken, they have. Thereafter, my lord, since nothing has been happened, so we raise this issue with the railway, page 80. And page 82, your lordship will see our letter to railway. Page 82, my lord, and except 14. Clause number 4, my lord, that sir, it is a matter of deep regret and surprise that in the year 2009, the then so and so, while later so and so has revised the value of land, treating it as a allotment and has increased the licensing fee by many folds from so and so only to 39 lakh. So and so only with retrospective effect from so and so. That's an amount of rupees so and so has been deducted. It was deducted from our running bills by so and so. Polygon. This has caused not only a great injustice to us, but also an acute financial hardship. That's why we have submitted several representations so and so. We have given letter to the authority. Thereafter, my lord, since nothing was done, so we again approached this honorable court. And before this honorable court, they have given a statement that they will consider my application as per the railway board circular. So we withdraw our writ petition.
Verbal assurance.
Verbal, it was reflected in subsequent letter. Here letter, page 84. 85 it is the withdrawal, my lord. So and so, Ms. DP was Mr. So and so railway land on Jagi Road currently being acquired and out of court settlement at this stage. If you have the submission of the lawyer, case is disposed of, not paid. Thereafter, we have given letter, page 86, after disposal of the matter, my lord. And thereafter, railway has issued my letter, page 87. May I read you? Please refer to railway board letter dated so and so, para 2, where it is clearly mentioned that licensing of ordinary commercial plots connected with railway working, as indicated in para 3 below, will be done with the personal approval of general manager in consultation with so and so. The periodical review may, however, be approved by DRM on recommendation of committee of divisional heads of engineer, commercial and finance department. Mr. So and so petitioner before your lordship set up the plant at Lamding after executing the land license agreement for the period 1988 to 1995. Hence, in this case, renewal of land license agreement is required as per railway board above guideline. It is therefore requested to initiate a renewal proposal at divisional level and send the necessary recommendation duly vetted and approved by the DRM to headquarters for approval of the competent authority. As per guideline of railway board, later along with the reasons for not reviewing the land license agreement since 1995. So land license, it was not reviewing by them, and as per railway board circular, my lord, it was directed to be considered by the, but nothing has been happened, my lord, till today. My lord, in the similar situated condition, my lord, other sleeper company, sleeper manufacturing company, page 88, my lord. Approach this honorable court, my lord. This honorable court, here, my lord, page 92, para 5. Maybe my lord may not be matching page 9, my para 5. Daya Engineering Limited order. Writ petition number 3341. Para 5. This court by an order it issued notice of motion and further observed that the deposit made by the petitioner in terms of the impugn notice dated so and so shall be subject to outcome of the writ petition. Pursuant thereto, railway authorities filed their affidavit in opposition. In the said affidavit in opposition, the specific stand of the railway authority is that the actual area under the occupation of the petitioner is so and so acres and the balance so and so.
We take your word that the facts are similar, save and except the land and the value.
Value, facts are similar.
Otherwise, the facts are similar. We are
similar.
taking your word for it.
And ultimately, this on
So at page 100, the court
100,
says that you will be entering into an agreement at the
consequently, para 18. Consequently, in view of the above observation, the impugn notice so and so is interfered with the direction to the respondent authority to calculate the land value and consequential licenses fee on the basis of clause so and so of the master circular. Till a license agreement is not entered into by the petitioner along with the respondent authority. It is also observed that if the petitioner does not enter into a licensing agreement, the respondent authority, in the view of the mandate of the circular that licensing agreement is must, shall take appropriate steps as envisaged under the law against the petitioner. The process of entering into an agreement for licensing
has to be completed expeditiously and not later than 3 months from the date of the order of subject to the petitioner is willing to enter into a licensing agreement, which is a must as per circulars for the use and occupation of plot of land in possession. My case is, my lord, squarely covered by my lord coordinate bench decision. What we are asking for, you review that land licensing as per the circular of railway board. This is not my circular, and that it was accepted by this honorable court, my lord. So, in my humble submission, in the same line, my lord, this writ petition may be disposed. So far as my lord, item number 15 is concerned, where they have raised the question of territorial jurisdiction, because my factory is situated at my lord Jalpaiguri, West Bengal. An order was passed by DRM NF Railway Katihar. They are saying that your factory is there, and order was passed by DRM Katihar. So this court has no jurisdiction, territorial jurisdiction. On that context, I would like to, my lord, the agreement was entered by the petitioner at NF Railway Guwahati, my lord. As per the agreement, all the disputed, the jurisdiction is Guwahati. My lord, the land which was allotted to me, my lord, it was allotted by General Manager NF Railway Guwahati. My lord, the impugn notice was issued by DRM NF Railway on the basis of the direction given by General Manager Guwahati. And as per my lord, Article 226(2), this agreement has been executed at Guwahati. As per the agreement, my lord, jurisdiction lies in Guwahati, and my lord, cause of action is in continuation of the action taken by the authorities at Guwahati. Moreover, DRM Katihar is under GM NF Railway Guwahati. Is working under GM Railway Guwahati. So, in my humble submission, as per Kusum Ignot, my lord, judgment, if your lordship is aware, my lord, this is maintainable and it may be disposed of in that way.
In both the cases, you want an order that they should enter into a license agreement with you and at the rates which
As per
which should be
circular.
fixed as per the circular.
Circle. That they, because in the item number 14, they have recovered from my running bills. In item number 15, my lord, they have not recovered it. But that may
They have not yet recovered.
yet. They are trying to recover.
Yes, madam.
They have not.
Lordship, although he was asked to submit a, that there was a license has been renewed, but whatever he had filed Lordship as additional affidavit, that is the first copy of the license agreement. That is up to 95. He was not able to submit subsequent license agreement. That is what.
There is nothing thereafter.
And secondly, Lordship, what case is that, Lordship? Although that license agreement is for 8.34 because of land, and he had paid land license fee up to 93-94. But apart from that, he is using 7.05 because of additional land. And for that, Lordship, this calculation was made, and subsequently we have asked him to pay the rent. Because then, Lordship.
So your stand is that the circular of 2005 has been followed? Is it? Are you impressing on that the circular has already been followed in his?
Lordship, yes, Lordship. And we are also saying that there is a difference between the case which he is referring and the present case.
Because
Factually,
in that case there was they were into contract and also into this thing, and here there is no. In his case, it was a contract and license, and in that case, there was no contract.
For
That
that
we've seen.
7.05 because of land, he had not entered into any license agreement with the railway authorities. And as per circular, Lordship, that master circular, for that land, he has to be treated as a fresh
For
case.
the rest of the 7.05
because of
for that.
that should be considered as a fresh case, and for that a fresh agreement has to be executed as part of master circular, and that is what the judgment also said that Lordship. But that part And
If the respondents are agreeable that this judgment, barring the small factual things, irrelevant factual aspects, if that judgment covers the case of the petitioner, so far as he is required to enter into a new license agreement qua the land which he never had any agreement with you, and renewal of the plot of land where he had a license but which had expired. If you say that this judgment would cover both the situations, where in case he is eager to enter into the license on the terms and conditions given in the judgment, if the respondents can do that, then we can close the writ petition. If we have to go into trying to find out which part of the land would be what and which part would not be that, this is not a fact court. And this litigation with him sitting on the land and you trying to recover is going to continue for a long time.
Whatever, my lord, I have possessing, that may be, I am not saying, because, my lord, it has been given by the railway only for the construction of this for their purpose. So whatever I am possessing, my lord, it may be calculated and master circular, your lordship will see.
A little while ago, we had reminded the councils that interjecting when we are
My lord,
interacting. We'll
I
come
am
back to you. We have never stopped any council from making any length of submissions
My
before
lord,
we,
absolute.
we,
I am
we
obliged.
pass an order.
I am
We
obliged.
hear totally.
I am obliged.
We will hear. What we are trying to find out is if the judgment covers, barring a few irrelevant facts, facts which would not be relevant to the licensing agreements, whether he had some other contract or not, these are all irrelevant facts. He is using a piece of land for whatever purpose. If you think this judgment can cover for you to go into a new licensing, a new agreement with him, or renewal of the old license by regularizing the past period in terms with the circular of 2005. Whatever the circular 2005 provides, that is what has been allowed by this court. We can allow you time tomorrow, day after tomorrow, maybe next week, whatever. If you can find out that if this judgment covers the case, and it will be helpful for the department and for the petitioner. He's using the land, you will get the money out of him. Litigation continues, there will be some interim order in some matter, both of them suffer. Would you like some time to do that?
but it's not nice.
Because with these kind of matters, unless we go into the facts thoroughly, it will be difficult to dispose of, and that will take a lot of time. We are not shy of doing it, but would it be required when all the facts are in your hands? And this is not a case where he has to come back again and again. Either you enter into a license or you don't enter into a license, matter ends there. That is what the earlier order I have seen has provided. If you come to page 100, if you see, it says, this opportunity shall be given if the petitioner opts for entering into the licensing agreement. If not, whatever is recoverable, you recover. You have him out of the land. Don't let him use the land. It is your land. Nowadays, natural bulldozers called elephants and man-made bulldozers are also readily available. Again, at para 16, it is not an aspect which this writ court can go into, but then being land, being money owed to the department, sooner we come to a conclusion, the better it is. Ninth. Matter has been heard at length. Full stop. And
Regarding jurisdiction on 9.5, because there is a specifically mentioned in the contract that what is the place of jurisdiction, and the arbitration clause is also there.
Also, when you have a discussion with the authorities, have a discussion whether jurisdictionally we will push it out of here. It will go and have the same result there. If the result remains the same, because a few days ago we have delivered a judgment where it says that if the arbitration clause is not impressed upon by you, we can still let you have, we can still adjudicate the matter to the extent where you agree upon. Mere presence of an arbitration clause will not shut down the whole process. So if it is an arbitration you want to sit down, by that time also remember that he will be sitting on the land.
But in the first case, the plot of land is in Polakpari, but in the second one,
It's a,
Lot of land is there, but
Your
but his contentions that everything started here
no, but the
and at the instance. of
demand
court
notice is
here,
from Katihar.
could be, but once we hold that the agreement was executed here for that land.
Because the clause, there is one clause that where the, no, demand,
Can-
where the.
Can a clause in the contract oust jurisdiction of a court? We have not heard so. We are yet to hear of such a law. Because you two people agree and you will oust, no, Guwahati High Court will not have the jurisdiction. Can it be done? We need to go
Constitution
beyond
provides.
the constitution. And so far as jurisdiction is concerned, let us place our mind before you. With all other aspects which need consideration for adjudication, when part of it falls within that initial contract has to be looked into. The initial order has to be looked into. Why that notice came under whose direction has to be looked into. If all of them fall within our jurisdiction, part of the course of action will arise here. Perhaps. We'll see on 9th, but not that we want to close something to your disadvantage or to his disadvantage. If it can be brought to a solution which is covered by an earlier order of discourse. Perhaps. Matter has been heard at length. List this matter again on the 9th of December for further hearing.
Item
8.
But if I am the workman, it
What had
petition,
happened?
it petitioner is the management, and they have challenged the award which was passed in the year of 2012, 2014.
Ah,
They have challenged the award in the year of 2000,
so would it be
and I have filed an application under section 17P.
would it be proper to hear you before they start?
They are absent. It is clear.
They'll come here. There are many a times when the counsels are on other courts. Yes.
Lordship, in this case, I am led by the case. He's on his deck.
Hmm.
Some
He has expressed urgency.
I know he has some urgency, but Lordship, it may take some time the hearing because if Lordship goes for disposal of the matter.
If we take it up, we'll try to go for a disposal.
Disposal entire matter, Lordship, that petition is another thing, and I'm.
What is the IA about? You were on some IA.
IA
What
under
is that IA for?
17B. Section 17B provides the interim relief by way of last known salary
Hmm.
during the pendency of the writ petition. The mandate of the section 17B is that during pendency of the writ petition, the employer, that is the management.
You were terminated.
Yes, Lord.
You
And
were terminated. Okay.
and the labor court passed a word directing the management to restrict.
Okay. How many respondents are there? How many workmen?
Two employees.
So what is your difficulty in adhering to 17B?
What happened with 17B, there's provision to pay the last year. What happened in this case, Lordship? I am the petitioner, but during the pendency of the proceeding, we executed a business transfer agreement.
Ah.
By virtue of that, we have transferred the entire system to respondent number 3. So what happened? All the assets and liabilities, including this case, by way of a disclosure letter, has been transferred to respondent number 3. Now,
Respondent number 3 knew about this pending litigation and all that?
because yes,
Having
yes,
knowledge?
yes. In the year 2010, the award came in the year 2014.
So why are you filing the repetition if all the liabilities have been transferred?
What happened, Lordship? This reference started in the year 2009, prior to the execution of the BTA.
True.
So we were made party.
Hmm.
So after execution of the BTA, we stopped appearing with an assumption that the respondent number 3 will take over the matter. So what happened? Because the issues were placed before the London Labour Court in our name. So it continued that way, and award was passed against us. That is Vidyut Mehta. So we didn't know about the award. The award was communicated to us by the labor authority. Once we received the award from the labor authority, we reported the matter to the labor authority regarding all entire fact. And here, the union of the employees who was pursuing the matter before the labor court, they also filed an execution petition before the learned district judge for executing the award, impleading the respondent number 3. They have not impleaded us. They have impleaded the respondent number 3 for execution of the award. And the respondent number 3 entered appearance there also. There they have said that we were not there in the award and so and so. So the union, who is respondent number 4 herein, respondent 2 herein, they withdrawn the execution petition and they approached the London Labour Court by way of an application under 33C2 against us for competing the amount of for competition of the amounting. Now our difficulty is that, Lordship, as because we have shifted the entire business to respondent number 3, we are not in a position even to reinstate them because the company is no longer with us. That will be a difficulty which I am expressing because this is the reason the award of 2014 was put to challenge before this honorable court in the year 2023. And Lordship may see this matter is 23, but we have challenged the award of 2014 because we didn't know about the award. And now, what respondent number 3 has filed their affidavit in opposition in the matter. They have said that PTA was executed in the year 10, but this reference is of 2009 prior to the execution of the PTA. So we may not be liable for the same. But I have annexed some labor court award also.
No, but if some workman is suffering due to the pendency of the writ petition,
Lordship,
one who has preferred the writ petition
Lordship,
has to bear the brunt during pendency of the writ petition. If you have any authority to transfer the liabilities to respondent number 3, do it in accordance with law. It is your writ petition.
already transferred.
It is your writ petition.
Yes, yes. Because what happened, Lordship, what I have projected before this honorable court, that during in the labor proceeding, the proceeding, reference proceeding, they entered appear. The respondent number 3. In the guise of, they entered appearance.
They entered appearance in the execution.
No. What I'm trying to project, the respondent number 3, the company to whom we have transferred our business, they have entered appearance, but in our guise. They have not incorporated their name. For this reason, this honorable court was pleased to call for the record of the labor court. From that, the Lordship will find the document exhibited by the respondent number 3, the document which the document exhibited before the learned labor court, which supposed to be before the labor court, but documents belongs to them. The respondent number 3 is Supermax. All the exhibited document, Lordship will find the Lordship may peruse the labor code record. Lordship will find that exhibit M and all. These are all service records and everything of the respondent number 3. But name remains Vidyut Metallic. That is the pit. That is the defect. May I submit?
Yes, respondent number 3, we are trying to give you the relief.
Yes.
We think workmen should be entitled to whatever is there in law.
Yes. I
So
want
let
to-
us find out. Yes.
Right, right.
Okay.
My hand is actually not correct. They have submitted that they came to know put the award in the year 2000.
No, I'm not saying 17. No, I'm not.
17, all right. It is an contested case. Award clearly says that they have appeared as a management and the award is directed against them. During the proceeding, they did not raise the fee about the business transfer acting. Throughout the proceeding, the award will confirm if to go to the award. They, as a management, participated and contested, admitting that the workman is their employee. The PTA was not raised at that point of time. The PTA is the afterthought. When they filed the writ petition, only they came up with a new issue that there is a business transfer agreement so that we are not liable to restrain or to compensate or to pay the back wages. It is an afterthought because it was not a part of the proceedings of the labor. The law is very candid and clear
that the plea which was not raised or proven in the labor court,
You
That
want
can-
you want your salary to be paid by them.
yes, they are,
You want your salary to be paid by them.
yes, yes. Because they are the management. They have contested the reference case as a management.
Yes,
They
madam,
have
what do
raised
you
the
say
issue.
about that exhibits? Yes, sir.
My lords, I am
Hmm.
extremely sorry when the matter was called out, I was facing some
difficulty.
technical
Tell us.
glitch, my lords.
There is an allegation that you did not inform the labor court regarding the transfer of the business.
My lords, the petition, my lords, this is serial number 8, I believe, right? That is, my lords, I'm appearing in serial number 8.
Yes, yes,
It item eight.
yes, yes.
Yes, it is it.
Yes, my lords, I'm appearing for the respond number 3.
Hmm.
My lords, since January 2024, there has been an NCLT proceeding against the company. So the company is currently in CIRP, and yes, my lords, in fact, in my reply also, I have pointed this out that there is a moratorium going on against the company. Now, my lords, my learned friend, the petitioner, is alleging his allegations are concerning the employees who were in fact terminated in 2008-2009 itself, before 2010, when the business transfer agreement was executed. My lords, my humble submission in my reply also, I have taken this ground is that, my lords, as on the date of the transfer, which is in 2010, my lords, the alleged workmen were no more a part of the company, which was transferring the business and the liabilities to me. When this event occurred,
That liability, would it include a pending litigation and liabilities arising out of that litigation?
I'm sorry, my lords,
When a liability is transferred to you under a business transfer agreement,
yes, my lords.
the pending litigation has to be divulged to you.
Yes, my lords.
Any liability that will arise out of that litigation will also be your liability.
Yes, my lords. But to address this particular issue, a part of the business transfer agreement, the clause of the business transfer agreement deals with this issue. If my lords,
What does it say?
Yes, my lords. Now, the liabilities part can be found on page number 208 of my reply.
208.
Yes.
We are only taking the Mr. Chaudhary, we are just taking this up to consider his
17B prayer.
We're just trying to find out what was the liability which he says has been transferred to him. Yes.
My lords are with me on page 208. That, my lords, 1.1.1, 1.1.8 clause number, the excerpt of which it reads, business liabilities shall mean liabilities including contingent liabilities relating to the business as set out in Annexure 2, but shall not include the liabilities listed in Annexure 3. Right below that, my lords, is Annexure 3, excluded business liabilities. In this, my lords, any liability to the extent that it relates to the period before closing. Any liability to the extent that it relates to the period before closing, whether asserted before or after the transfer date, including but not limited to any liabilities for product defects and or so and so, and sold by the transferee, any environmental liabilities, liabilities for personal injuries or property damages, all liabilities relating to or involving the employees or contractors of the transferor, including any allegation of any of the foregoing. My lords, the business transfer agreement had in fact contemplated, and therefore this clause was introduced in the business transfer agreement, my lords. It is annexure number 3. My lords, my humble submission is twofold. One, the factor, my lords, that the liabilities pertaining to an employee or such employees or workmen who were no more a part of the transferor company as on the date of the transfer
cannot be included in the business transfer agreement or the
So
liability.
now the order of the labor court, which says that these persons should be reinstated.
My
They
lords,
cannot be reinstated, they will not be your liability.
my lords, it cannot be so. For
If
the
we take you, if we understand the clause in the manner you are trying to explain, then suppose we dismiss this writ petition
my lords,
and the employees remain to be reinstated.
my lords,
As on the date of transfer, they were not your employees,
they were
not
not
the company's employees.
my lords.
Then where do they go? How do you execute that order of the court?
My lords, the arrangement between the parties by way of a business transfer agreement was entered into consciously between both the parties.
I understand. You
transfer
have
and
to
transfer.
also tell me that that conscious has also to be reasonable.
Yes, my lords.
There is an order of the court directing a reinstatement.
My lords,
Today we dismiss the writ petition.
my lords,
Assuming
my lords.
these employees have to be reinstated somewhere.
If not reinstated, my lord,
You never agitated their the order for their reinstatement.
I'm sorry, I did not.
The order for their reinstatement, which has
Yes.
not been taken up by the erstwhile company, the earlier
Yes.
company,
Hmm.
they have agitated this issue.
My lords,
That they should not be reinstated.
yes,
Now they were part of the business which has been transferred to you.
my lords.
In case the earlier company loses this petition, these people will have to be reinstated.
Yes, my lords.
Where?
My lords, as per the agreement, it should be with the petitioner in this matter.
Where is the petitioner? When the business is not there, the business has come to you.
My lords, in that sense, the liability to reinstate, my lords, is non-est in that sense, because
So these persons will never be reinstated, while persons who were on the job as on that day and
My
were
lord.
not, let us say, illegally terminated, they will remain with you, but the persons who were illegally terminated will be out on the streets.
I understand what is falling from the bench, my lords. But
we will try to understand what is reasonable, not what is arguable.
I get it, my
Is a
lords. One more
difficulty.
small submission I want to make, please, with the
Yes,
liberty.
what we are planning to do is, of course, subject to what comes up in the arguments.
My lords.
During the pendency, the salary has to come from some part if we think that 17B is to be implemented.
My lords. My lords.
And whichever company you can find out the liability on, you can recover from whomever you want. But for that,
my lords,
workmen who are suffering the litigation, they should not go home hungry.
Exactly.
My
How can
lords.
they go home hungry?
My lords, that is.
In Assamese, they say, "Dui mohor jujot birina moron." We are not letting the birina die here. You find out your liabilities, that is up to you and
My
the
lords, very
other
well.
company.
In that sense, my lords, one more small submission, if with the liberty, please.
Yes.
My lords, if there is any claim, let's for the time being, let's say that if there is a claim that the workmen have for the time being against the respondent number 3. Right? So in case there is a claim against the respondent number 3, they are well within their rights to approach the NCLT and establish their claim. Because as it is, my lords, the respondent number 3 is undergoing CIRP before NCLT Mumbai. And my lords, under
that is why the push towards the erstwhile company. Okay.
My lords.
My lord,
Yes, we will come back to
can
you.
I
Very
just,
well, very
if your
well.
lordship would kindly take the writ petition, please come to page 31.
31.
Look, we cannot argue for the sake of arguing. There has to be something reasonableness.
Yes.
1.1.15. Disclosure. What is disclosure letter? Disclosure letter shall mean letter from transferor to the transferee in relation to transferor's warranties executed and delivered immediately before execution of this agreement in agreed from together with the disclosure data. Now, my lord will kindly come to page number 53. This is the disclosure letter. How can they, my lord, now say no to this? Now, this was written by the petitioner to respondent number 3. This is the disclosure letter. This is the part of the agreement. Business transfer agreement dated November 18, 2010
between Vidyut Metallics Private Limited and the transferee, we refer to the caption agreement unless context otherwise requires. Words and expression defined in the agreement shall have the same meaning where used in this letter. We wish to record the following preliminary matter in relation to this letter. This letter, together with the schedule thereto, constitutes the disclosure letter referred to in the agreement. Please come to all disclosure in the disclosure letter are to be taken as relating to respective transferors' warranties to which they relate and shall be deemed to qualify the any other transferors' warranties. 3. Information contained herein is not prepared or disclosed with a view to its potential disclosure to third parties subject to applicable laws. This information is disclosed in confidence for the purpose contemplated in the agreement, is subject to confidentiality provided contained in the agreement. So therefore, my lord, this disclosure letter is very much a part of the agreement and it was addressed to the respondent number 3. Then now my lord will kindly come to page 72.
172.
Yes. Schedule 4, Vidyut Metallics Private Limited, contingent litigation liability. Has your lordship seen that, my lord? Then my lord will kindly come to 74. Serial 72. Application number 6 of 2009. This is Milord, Labor Code Guwahati matter. Center for Medical and Sales Representative, 14,25,000 crore. So, my lord, it was very much a part and parcel of the agreement. And this was the disclosure letter. Now, how can respondent number 3, my lord, come up with any plea that they will not take over the responsibility?
What about that NCLT matter he is now saying?
No, that's a different aspect. So, therefore, my humble submission is, I do appreciate the position of my learned friend's client. He cannot be left high and dry. So therefore, we'll decide the matter as to whether petitioner or respondent number 3 is liable for this liability. First, he will take a call. Immediately on reopening, lawsuit will fix the matter and we'll make advance or argument. Let respondent number 3 also say.
Are the pleadings complete?
Yes.
There is no further pleading to be done.
No, Miller.
Decided in January.
Yes.
Let us not only the IAs will be taken care of if the entire matter is disposed.
Entire matter. One thing is the clerkship. My apprehension is very technical. Once the matter is for hearing, if it doesn't reach month after month,
Have you gone through the cause lists and the disposals and the matter reaching or not reaching for the last around 2 weeks that we have been holding court here, or for the time that we have been holding court?
Not.
You have not. Please
Not.
be informed.
Not.
It was on a single day that 3 matters had to be kept over because of paucity of time.
Cannot keep my cakes
So apprehensions which are expressed better be backed by some.
Tatas. Can have it on 6th or 8th, Miller?
Yes.
My lords,
6th,
I am
8th.
6th or 8th, my lords, of January, my lords. 6th would be preferred.
6th.
6th would be preferred if it suits my lords.
6th of January.
Not.
Yes. The learned counsels for the party heard Mr. K.N. Chaudhary, learned senior counsel, assisted by Mr. So-and-so. Also heard Mr. So-and-so, learned counsel appearing for the workman. Mr. So-and-so appearing for the respondent number 3. You are
Three.
respondent number 3.
My lords.
Are you there? Respondent number 1. At the consensus arrived at by the learned counsel for the parties, list this matter on the 6th of January 2026, where an attempt shall be made to adjudicate the matter finally, full stop. Adjudicate the writ petition instead of taking up the IAs for consideration today, full stop. That'll do.
Diplomat.
On 6th, another 20-25 days.
Not.
Hearing, item 10.
My lords, any written submissions are to be submitted? Are we permitted to submit a written submissions or
Yes, that
we
permission
can
is
argue
always
it on the same day?
that is always there. You can file it even after the matter is heard.
Very well. So 6th, we will be arguing the matter at length. Highly obliged, my lords.
Yes,
Better maybe take some other day if allowed your.
subject to his convenience and no objection. Yes.
Okay, it's a long pending.
See, it's 2016.
Yes, sir.
We have to give some reason why.
No, it's
Hmm?
No.
What is the matter about?
we challenge the order
Just
of
the subject matter. in
Yeah.
fact.
we challenge the order of an ombudsman, Your Lordship,
Hmm.
whereby our application was rejected by the learned ombudsman Tito.
Hmm.
And in our application, we have stated that they have charged interest on prepayment charges
Ah,
on cash credit account closure of prepaid closure of cash credit. One and the second one is that they have charged some commission illegally while discharging the bank guarantee.
so so just for this thing understanding,
Yes.
this repetition is taken up. If this repetition is not for you to be paying something because you've been
No,
asked to pay
no,
something. It is
no.
because you want to recover something. From
Yes.
it.
No, we have
Yeah.
deducted.
Huh?
They have already
You have
deducted.
deducted.
You
he needs to
recover
recover the
it.
same.
Right.
It can be taken up sometime in the first week of February for final disposal. Should we fix it or
Or in the
January?
month of January or
January?
yes, sir.
Choose a
Any
date.
date.
Choose a date.
January ka to date.
Choose a date because I'm going to put in the order that the
No, no,
date is being chosen by you.
no.
You cannot be absent.
No, I'm always be here, Your Lord.
We noticed that.
Only that tomorrow I am going, so that I required some. That's why I am.
Okay.
I think that this matter will be taken up by 3. So that is why I am.
All right. The learned counsel for the parties have submitted that the matter would require some substantial hearing. And therefore the matter may be taken up on 23rd of January.
What did you?
Oh, I'm looking at
on,
the
in the
25,
third, in the third,
2025 list.
Your Lordship, maybe take it up on third week of January, Your Lordship.
Hmm.
Be on a date to be fixed by the rate.
On the 3rd week of January on a date to be fixed by the registry.
Your Lordship, I kindly
Prayer,
date
huh?
is allowed, but maybe given a 3rd February, if it's right. Keep a date, that's fine,
29th of January. Kar dijiye.
29th.
29th of January for disposal.
Got.
Parties are requested to be prepared.
Item 11. Obliged, Lord.
None appears for the petitioner on call. Matter is of 2017 in the interest of justice. List again. After 2 weeks. Baro? Oh. I told him that no matter has been left unpaid.